Be cool, be kind, be classy. The cupcakes are sweet and sexy. Have fun and enjoy the journey. Or just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. There's a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish and Latin, it's not just for Manhattan. It's for Goethe and the Shakeouts. Ridiculous that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Hello. Happy hump day. Today's hump day. Today's Wednesday, June 17th, 2026. And the Karen Reed hearing that we thought we were going to see, that I was going to watch on Zoom and then come tell you about after it was over, they decided not to turn on the Zoom today, but it's okay because I found a live feed. And so we're going to watch it live. It only started a few moments ago, but I'm going to give people a chance to come in. So give people a chance to come in, because if you're waiting on the Zoom, abort. The Zoom isn't happening. Don't worry. I got you. We're going to watch it. Unfortunately, because mass courts was glitchy all day yesterday, I couldn't get the opposition papers, Colin's opposition papers, until today. And I was going to do that with you first. But of course, things change, we're a very spontaneous channel here. And I've got it. So tell your friends, tell everybody. I also got this really cool thing that if you're interested in this, I'm going to link it. Check this out. It's a heater and a back massager that you put behind you on the chair. Oops. And look at this. It massages your back. It's like $30. If you need a last minute Father's Day gift, get it. It's on my Amazon storefront, which is linked below in the show notes. All right. So Colin Albert enlisted in the Army, and he didn't want to give all the documents that Karen Reed's team had asked him for. And so they said they would reschedule his deposition that they had noticed in April. And while they were in the process of rescheduling and working out the parameters of all the documents that they wanted Colin Albert to provide, including all communications between him and practically anybody involved in this case, text messages, etc., other things, they decided to, and they said, well, we can reschedule the deposition for any day except for these 2 days. Charles Waters, aka Chaz, was going to do the deposition, and there were 2 days that he was going to be out of town. And so they said, then all of a sudden they say, oh, on May 20th, Colin Albert just told us last night that he's enlisting in the Army, and so you can only do it within the next 13 days, and only these 2 days. And they were exactly the 2 days that Chaz Waters was going to be out of town. So what did they do? Mark Diller subpoenaed Colin Albert, or sent him a notice to come for a deposition. And under the rules of court in Massachusetts, the civil rules, you're supposed to give 7 days notice for a deposition. And they complained that Karen Reed's team didn't give Colin Albert 7 days. But you know what Mark Diller did? He gave 6 days, and they still went ahead with the deposition without Karen Reed's team, because they were like, hell no, we're not coming, because he didn't give us any of the documents that we wanted. And all of the communications that they wanted to cross-examine him on. And now it appears that it is too late, because Colin Albert is off to boot camp. And the hearing just started moments ago.
Yes, Your Honor.
I don't know if there's anyone in the courtroom, any viewers watching, but it's okay, because CBS Boston is out here doing the Lord's work for us. And boy, is it a pissing match in the papers between Aaron Rosenberg, who is Karen's attorney in this case, and Colin Albert's attorney, Tuxbury. I mean, I've never seen lawyers go back and forth in papers like so vitriolically and with ad hominem attacks and all kinds of crazy things. In fact, Colin Albert's attorney is actually accusing Karen Reed's attorneys of ethical violations. Like, you just don't see that ever in court papers. This is really wild. Let's see if Judge Gildea is going to put up with it. Let's do it. Here we go. This is today's hearing. Just started moments ago. I got the live stream. Don't worry. I got you. Here we go.
When is Mr. Allen going to be produced for deposition?
He appeared for that deposition on the 20th.
Produced for deposition.
All right. I may need to boost this. So as always, we have to modulate the sound because a lot of times YouTube or whoever's recording in the courtroom, let me just turn this thing off because I think it's too loud. Whoever's recording in the courtroom, it also has heat, this thing that you put on your back. And you can also, it also comes with an adapter for your car. So you can put it in your car. You can use it in your car. It's got one of those like cigarette lighter adapters. I love it, but I think it's making too much noise. And also it's making me move back and forth. So hang on. They canceled the Zoom. Yeah, they canceled the Zoom, but see, there's a local channel. And let's I Spy. I may have to boost it, so we're gonna have to try it. Let's see.
He appeared for that deposition on the 28th for subpoena, and then he is.
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition?
How's the volume on that? I might have to boost it more. Let me see if it fixes itself.
Back up here and be deposed.
Okay.
Now,
Audio
let's
is
talk
terrible.
about the
Does it need to be louder?
status of any
Tell me. Mods, tell me. In my storefront
When is Mr.
on Amazon, which is linked in the show notes below the video, you can find this gizmo, this back massager thing. It's like 30 or 40 bucks. It might be on sale. It's under, I think it's under the self-care section because you know I'm big on self-care. Okay, let's see if this is better.
Allen going to be produced for deposition?
He appeared for that deposition on the 28th for subpoena.
Is that better?
He is.
Hang on, let's lay the groundwork.
Yeah.
You agree you
Okay, this is going to be on 10. This is the most I can boost it. And when I boost it through this booster, sometimes it distorts the audio. So we can't have everything. I'm not a cupcake. I can't make everybody happy. If it's boosted on 10, which I'm doing, it's going to be a little bit distorted. You have to deal with it. No complaints are going to be accepted today. Scott's here, little cupcaker here. They're not going to deal with the complaints. Okay. Here's let's just zoom in a little teeny weeny big. Looks like Karen's here in the front row, looking a little bit blonder, sitting next to her dad. We're going to start from the very beginning. So don't worry. You didn't miss a thing.
produced for deposition?
And they must have started maybe after their appearances. Okay.
Yes, sir.
There is also no closed captioning when it's live. It doesn't work. Okay. Doesn't work. Don't tell. Okay. I'm doing it my way. This is called my way. If you don't like it my way, go find someone else who's streaming it. Okay. Okay. Love you so much. Here we go.
When is Mr. Allen going to be produced for deposition?
He appeared for that deposition on the 28th for subpoena, and then he is.
Hang on, let's lay the groundwork.
Yeah.
You agree you accepted a deposition subpoena?
He was served a deposition subpoena for April 29th.
Then you talked about taking it off. It didn't go for it. When's he going to be available?
At this point in time, Your Honor, I'm not sure. It'll be sometime in the fall. He's got 10 weeks training.
Not going to happen.
He's in basic training right now. We have 1 hour a week communication with him.
I don't.
Okay. Can you hear? Because they are now talking about, this is Colin Albert's attorney, who is also the plaintiff's attorney in the defamation case. This is Tuxbury, I believe. He's arguing and explaining to the judge why Colin Albert is not going to be available to give a deposition until the fall because he's in boot camp and we can only speak to him 1 hour a week. And this is it. And the judge said, yeah, no, not happening. Okay, listen to it again. I know there's a lot of people coming in right now, so I don't want you to miss a thing. So we're just going to scooch it back a tiny bit. Jimbo Tuxbury on the mic arguing or explaining to the judge why Colin Albert cannot come for deposition until the fall.
Not sure. It'll be sometime in the fall. It'll be sometime in the fall. He's got 10 weeks training.
Not gonna happen.
He's in basic training right now. We have 1 hour a week communications with him.
And I don't dispute what you're telling me, but I'm not gonna simply rely upon a statement in court that a witness can't be produced until the fall. So go find out when he can be produced before that.
Okay. I will, Your Honor, try. We won't be able to talk to him until Saturday. I'll talk to him Saturday briefly and see what we can figure out.
But it's not a matter of figuring it out. It's a matter of you saying to him, there's a duly issued subpoena. As I said in one of my pleadings, in this case, which you weren't involved in, a subpoena needs to mean something. Just as an attorney agreeing to continue needs to mean something. And it shouldn't end up in front of me in these circumstances.
I appreciate that, Your Honor. We're in a situation where we learned on the 20th and we let them know the same day. I know they say there's games here. We informed them the same day that we found out this information that he had been accepted into the military and had a shipment date of June 2nd. We said, please take his deposition during this period of time. I know you want to take it. And at that point in time,
Let's not put aside the fact that you represent him in another case.
certainly.
Right?
And
That was
he's
called, that was filed not that long ago.
yes.
Boom. Boom. Let's not lose sight of the fact, Jimbo Tuxbury, counselor, my brother, that you represent him in another case too, where he's a plaintiff, a defamation case, where he just filed a lawsuit. And now you're telling us he's shipping off to the army like Conrad Birdie and he's not going to be available for deposition. Usually when the judge says, go find out when he's going to be available and come back, that means like now. That means now. Go in the hallway, get on the phone with your client and come back here now and tell me why he can't appear for a deposition. And so he's not putting up any games. He's not putting up with any games. Okay.
So certainly, maybe a party that's going to prosecute an action such as they have alleged should stay in touch with their attorneys and let them know what's going on.
Certainly. And we know what he's going through his first 3 weeks school. And then
Client has an obligation. The client has an obligation to talk to his attorney and to keep him abreast of his availability. And I'm going to say it again. The only live stream available is this one. It is on 10 boosted. Earbuds are your friend. If I'm too loud for you, you can go somewhere else and watch it. I can't please everyone. I'm not a flippin' cupcake. I have turned my mic down as best I can. There it is. Now my mic is on something like 9. Okay. And then other people are going to complain that the court is I can't please everyone. Okay. Here we go.
this ends, he'll go to 10 weeks basic training. We're not sure where that will be. The Army will assign him that location of where his 10 weeks of basic training will be. He'll be on, like I was saying, Your Honor, he'll be on leave in the fall. So in terms of I appreciate it.
Let me just make it clear. We're not waiting till the fall.
Okay.
All right? Discovery ends in this case on August 17th.
Let me make it clear, he says. I don't care about the Army. Discovery ends on the 17th, on August 17th. I'm done here. He's not accepting it. He doesn't care about the Army.
Okay. So you're going to go find out when he can get back up here and be deposed.
Okay.
Now let's talk about the status of any discussions between the attorneys as to the scope of the production. I agree with Attorney Tuxbury that the scope of the subpoena is excessively broad.
Okay, that means they've asked for certain text messages and communications between Colin and just about everybody from like January 29th, 2022 to the present. And the judge says he agrees that it's too broad. Let's narrow this down. Colin Albert has said through his attorney that, I'll just whisper, that he doesn't have anything that he looked, and the only thing that he has is the screenshot of the message between he and Allie McCabe. That's the only thing that he has. The only thing. That's what he says.
I know there have been discussions, but I don't know where you're at now. Have you had any recent discussions?
No, the discussions are what are laid out. And if Your Honor is inclined to ask us to, we can continue to work on the document side and report back to you in a few days.
Great.
Yes, I mean, we made our proposal, Your Honor, with respect to, issues about what this case is about, which is the death of Officer O'Keefe on the night of January 29, 2022. He searched for all communications with law enforcement for the entire period of time, look for other ones. We never heard back. We got this motion in response to that. I mean, we're happy to look at other stuff here, but I think to your point, the asking for private conversations, communications, really from our perspective is a non-starter without being tied to this case.
To you, Attorney Rosenberg, collectively, let's keep in mind, okay, that I know there's the other case, but you're talking about a non-party.
Understood, Your Honor. And I don't know if you would want to, but I'm happy to get some thoughts from you about because what Mr. Tuxbury is referring to is the extremely narrow two categories that they said, we'll search for these and we don't have any documents. We search and we don't have any documents other than the text chain that's already public record. So I think that is certainly too narrow, but I also take your point to me that as it stands, that the subpoena is too broad. There is obviously, as you are aware, Your Honor, there's more than wrongful death alleged here. The false narrative is part of the claims the plaintiffs have brought in this case, and that obviously relates to much longer than January 28th and 29th, 2022. So to the extent, there's burden.
I don't know that it extends 4 years.
And I'm not trying to argue it because I don't understand that you want to decide that as a fact right now. All I'm saying is it's broader, and this is kind of my point. I think it's broader than what Mr. Tuxbury and his team interpret it. You're telling us that you think it's narrower than what we interpret it, and that's taken, which is why I suggested we have a conversation about maybe meeting somewhere in the middle, and I'm fine doing that.
When can you have the conversation?
Tomorrow?
Sure. Yeah, I'm open to a call anytime. Just call me. I'm available tomorrow afternoon. We have a meeting for something else tomorrow afternoon.
It's not me that has to call you.
I understand. It's anyone. Damon can call me. I never know who has to call me because there's allocation of attorneys, so you have to know who you're talking to. But yeah, I can have a conversation about that. But obviously,
Don't be a jerk. He was a jerk in his papers. He was a jerk in his papers because he went over Rosenberg's head. We're going to look at the papers after this. He went over Rosenberg's head. And it's very unprofessional what he did. And we're going to look at the papers so that I can show you. But listen to what he says. I don't know who I'm supposed to talk to.
Damon can call me. I never know who has to call me because there's allocation of attorneys, so you have to know who you're talking to. But yeah, I can have a conversation about that. But obviously, as you know, this is a wrongful death case with there's an intentional infliction claim based on a false narrative. In many respects, that false narrative claim is the other side of the coin of the wrongful death, right? If she has said things that someone else did it and they show she actually did it, a priori, false narrative. It's not the defamation case. This is not the harassment case, the criminal harassment case that's proceeding with respect to Mr. Carney in Norfolk County. And so we're happy to consult with them and look for more stuff. I think there's a disconnect because there's a different view of what happened here. And so I think they're frustrated when we say we don't have any documents because he simply doesn't have any.
Was he about to say there's a different view of reality? And then he stopped himself? Hold on. This is Jimbo Tuxbury. Bob Weir is here. Colin's lawyer, Jimbo Tuxbury. I believe, unless this is Maddie, because now I'm confused. But Tuxbury was the one who was doing all the emails back and forth. If anybody knows differently, tell me.
In Norfolk County. And so we're happy to consult with them, look for more stuff. I think there's a disconnect because there's a different view of what happened here.
Reality.
And so I think they're frustrated when we say we don't have any documents because he simply doesn't have any. We're willing to consider searching for more and expand the time scope of that search, but in likelihood the answer is going to be the same.
I understand you stand before me representing a non-party.
Yes.
But we're all aware of the other case in which certain allegations have been made. So you're going to have to do some of those searches sooner or later.
Of course, Your Honor. I think what I'm just trying to do, following the guidance of this court, this case is the wrongful death case. we're going to do discovery, and we're doing discovery in the defamation case, and we're going to get document requests, I'm sure, that will be broader than that. That's a different case here. And so,
Dude, they're all related. They're all related. Because if Colin Albert had something to do with the murder and or cover up of murder of Boston police officer John O'Keefe, and if he lied on the stand, all of this stuff is interrelated. Don't pretend that it's not. Don't pretend that you can just take Colin Albert's deposition in another case and it's going to be the same. No, because this wrongful death case, they are saying in their intentional infliction of emotional distress claims that Karen Reed provided a false narrative, and that false narrative gave them emotional distress. And so she's entitled to defend herself. And here's what's going to happen, counselor. If your client doesn't come up with any goods, then a Rule 17 motion to his carrier or for his iCloud might be entertained. And so, again, you better want what you wish for. You also represent him as a plaintiff in the defamation case. So it's all related.
the issue I have, Your Honors, as a third party here in this matter, is resource issues, right? It's quite expensive here. We're going to have to do this in the defamation case. That's going to be different and separate apart from this one. So all I'm trying to do, Your Honor, is kind of ensure that not needlessly harassing a third party here in this action. I appreciate what you're saying, Your Honor. We're going to produce those documents in response to the RFPs when we get them, right? Obviously we are. We've already gotten one set of RFPs from Ms. Reed in that case too. So I do appreciate it. I'm standing here as a third party, subject to the protections of Rule 45 in this matter. And my client in this instance is also a party to a defamation case originally filed in Barstow County, now appearing before Your Honor. But I think in terms of like the scope of discovery and forcing him to kind of like do duplicative discovery, that's a little excessively burdensome. And so I think it's appropriate to keep our focus on what they want for this case. Yeah, like I mentioned before, it's not before Your Honor. We had thought that consolidation for discovery purposes might make sense to avoid this kind of situation, and it was rejected. That's fine. I'm not asking to address it. But
Although I don't think the hospitality defendants would really want to go on.
I will tell you, Your Honor, they actually said okay. I'm not to speak for them, but they said okay to it. But that's these issues that I'm dealing with, Your Honor. I appreciate what you're saying with respect to the defamation case and discovery in that matter too. But that's why here, I think the appropriate scope for this case is, as you've laid out before, which is what happened to Officer O'Keefe on that night. And on that point, as we put out in our briefing, Colin Albert simply doesn't have a lot to say.
He's just going to start arguing.
Yeah, we'll consider Bert. No,
What depositions are scheduled for Monday? I should know because I asked you for the calendar, but so I don't remember.
you know, Dan, Monday is. Oh, Monday is Nicole Albert, but that's going to be that's a subject of a separate motion to compel. That's pending via 9A. That's going to be filed hopefully early next week.
Great. So, hate to ruin your weekend, but you and your team can review what you got today, and the two of you can talk. We can all.
Wait, hold on. Some people are saying they can't hear me now. I don't care. Oh, Jennifer McCabe is there. There she is. There's Jenny 3 times. Jenny 3 times, and Chris Albert showing up, even though they're not even parties to this case. This is the O'Keefe versus Karen Reed, CF McCarthy's and Waterfall case. And Jennifer McCabe and Chris Albert have chosen to show up today. Thank you to CBS Boston for airing this live. He's like, well, the bars agreed to consolidate discovery, but they don't have to. Chris Albert, for those of you who don't know, in the blue shirt is Colin Albert's father. Apparently, according to some reviews on Google, he makes a mediocre chicken parm at D&E Pizza. He also used to be town select board member for Canton Town Select Board. Yeah, the judge is using a tin can and a string. I get it. That's funny, but we have no choice. The Zoom was aborted. They're not doing Zoom. This is all we got.
That's going to be that's a subject of a separate motion to compel. That's pending via 9A. That's going to be filed hopefully early next week.
Great. So, hate to ruin your weekend, but you and your team can review what you got today, and the two of you can talk. We can all come back Monday afternoon at 3 o'clock. Talk about this again. Does that work for
When you said your team, were you talking to Mr. Buck? Okay. Let me just make sure.
Zoom or in person, Your Honor?
in person?
Perfect.
Yes, that works.
I will not be available, Your Honor. I think I mentioned this at our Rule 16 conference. I'll be gone for a while.
Maybe you have someone that could report on the results of your discussions.
Certainly, I can do that, Your Honor, and that's part of the issue with respect to resources. Obviously, I have my colleague Kieran Murphy, who's here with me, pro hoc into the defamation case. It costs money to do that. It's not cheap, so I can try to find someone in my office to respond, or he can respond without appearing before Your Honor, and then we can figure out.
We have no objection to making that easier, however we can.
But Your Honor, it's really expensive. But Your Honor, I have my associate Kieran Murphy here. It's really expensive for me to bring in other lawyers. But I'm going to be away for a while, so I'm going to find someone else to sub in for me. So why can't they do that too? Mommy, mom, daddy. Why can't they do that too?
Say that again?
To the extent there's a way that Mr. Murphy can appear, we're fine with it.
We'll let him appear. Right?
Yes, I mean, I'd asked today. I understand that he's not pro hoc into this case. That's all.
We have no
Don't
objection.
tell anyone, okay?
We'll keep it a
Enjoy your
secret.
vacation. After you talk about Attorney Rosenberg.
Yes.
Anything else? You have other motions that are coming?
We do. We have a motion to compel that's coming, again, next week. I think the opposition is due early next week. It'll be filed with you shortly. There's one pending motion from the plaintiffs, I believe, seeking additional information in response to interrogatories. That's it, I think.
At the moment, I believe that's accurate.
Okay, well, see if you can agree amongst yourselves as to a date to have another hearing the week of June 29th on those motions, soon to be filed, all right? You don't need to do it right now, all right? Anything else?
Can we address one topic at sidebar briefly, Your Honor? Thank you.
Yeah, Your Honor, can we talk about them accusing me of ethical violations in their publicly filed papers? There's Karen and Bill Reed, some other people in the gallery of the courtroom. I don't recognize anybody. Maybe you guys do. Judge wants dates when Colin Albert's going to be available. He says, nope, I don't care. I don't care if he's in the Army. The deadline in this case is the 17th of August. Come back and give me some dates when he's going to be available. Go talk to your client. Tuxbury says, we can only talk to him one day a week. I can't talk to him until Sunday, I think he said. Is that Brenda Sweeney? I didn't notice. I see Jennifer McCabe. I spy Jennifer McCabe, Chris Albert, and I guess that's Kieran Murphy, because Tuxbury pointed him out. Jennifer McCabe does not look happy. No, look, the cameraman knows his assignment. He has zoomed in on Chris Albert and Jen McCabe, and Jen just looked at the camera like they're on their worldwide privacy tour. Their worldwide privacy tour. Let's put the worldwide privacy tour up in the corner. If you watch South Park, you know that it is season 26, episode 2. Meghan Markle and Harry of Canada wanted their privacy, and there they are in their house, curtain twitching out the window with all kinds of signs outside their house because they moved across the street from Kyle. They really, really, really wanted their privacy. Give us our privacy, it said all over their house. Curtain twitching. So apropos. Karen's looking beautiful in a pink suit. Some lighter highlights. I think that's Scott McGinnis. The Sweeneys are there. Nobody's wearing shirts with any logos on them.
Anything else, Councilman? So the next day we have is Monday. So we have next Monday, and after that, we have 9:45 on the 26th for a status.
That's still by Zoom, Your Honor?
very much.
Thank you, Your Honor.
See you on
And
Monday.
that's it.
All right.
And they're coming back Monday.
This matter is continued to June 22nd, 2026 at 3 p.m. in person for further hearing on this motion. Thank you all.
Monday, 2 p.m. You better come back here with some dates, Mr. Tuxbury, when your client, Colin Albert, will be available. Oh, here's another thing that people say. Not a complaint, but here's what I'm going to do.
I'll try to. Yeah, just say.
I'm going to mute the court, and I'm going to put my volume back to normal because everyone was complaining I was too loud. So hold on. Hold, please. Okay, now I'm auto, so you may need to adjust your own volume. There's Karen, looking lovely in her pink suit. We want privacy. We want privacy. We want privacy. He needs to come back on Monday with some dates when Colin Albert's going to be available to come back for his deposition. I don't know who this man is walking in the emergency exit. Diane Gallagher telling us that in the gallery we saw the... All right, that's it. Sorry about the volume issues, but it's not my problem. That was a CBS Boston problem, and always the judge Gildea sounds like he's in a tin can, talking with a tin can and a string. That was a great analogy as to what the court sounds like always in that courtroom. And at the very least, CBS Boston was in there to live stream it for us because there was no Zoom feed available. There just wasn't. Nope. The Massachusetts State Police motion is going to be decided on papers. The judge wasn't having any of it. He said, I don't care if you've all agreed to adjourn it. I'm going to decide that on papers. He doesn't have any more patience or any more tolerance for this nonsense. So thank you to CBS Boston. Let's take a look at Colin Albert's opposition to the motion to compel him to appear for a deposition, because I've never really seen like a pissing match like this in between attorneys on paper. I thought it was kind of gross. If any of you have read it or seen anybody else read it, you can give me your thoughts. Yeah, he's going to come back Monday with more excuses. Of course he is. Corey Hopkins is here. She's a queen. She says, bookmark this hearing to use when Tuxbury makes the opposite argument in the defamation case in a few months. Right. Exactly. Let's take a look. Many of you may not have seen Colin Albert's excuse for why he did not appear for a deposition. The deposition that was noticed by the defendant, Karen Reed, in this case. Okay, so this is the case, just to rewind a sec. This is the wrongful death case of Paul O'Keefe, John O'Keefe Sr., Peggy O'Keefe, and his niece Kaylee Furbush against McCarthy's The Waterfall and Karen Reed. This is the wrongful death car accident case. Okay, in order for the O'Keefes to win this case against Karen Reed and the bars, they have to show that John O'Keefe was hit and killed by Karen's car. Personally, I do not think that that is a burden that they are going to be able to meet, either on paper or in front of a jury. Because we know, because we've been here for a couple of seasons now, John O'Keefe was not hit by a car. A car did not hit John O'Keefe because physics, science, medicine, expert witnesses, injuries. And that's why I became so invested in this case, was because of the injuries. The injuries to John O'Keefe do not, and I repeat, do not look anything like a pedestrian versus motor vehicle accident case. They just do not. Here's Colin Albert's excuse why he could not appear for a deposition, and it's his opposition to this motion to compel. And again, they kept pointing out, he's a non-party, judge. And the judge said, let's not lose sight of the fact, Mr. Tuxbury, that you represent Colin Albert as a plaintiff in another lawsuit that you just filed, a defamation case. And he's like, yeah, but, you know, I tried to consolidate discovery with them and they said no. And the judge is like, yeah, because my deadline for depositions here is August 17th. When can your client appear? And Tuxbury said, I don't know. He's in boot camp. You know, he didn't tell me until the 20th. that he was enlisting, and he won't be back until the fall. And judge said, that's not happening. Literally, Judge Gildea said, that's not happening. I know the audio wasn't good. You can rewind right here and go back and listen to the judge say it. He said, that's not happening. Go out and get me some dates. I'm not going to read this word for word, but I'm going to read some of the snark to you, and I'm going to read some of the reasons, all the reasons. He pulled out the reason card. He's got the reason card. And based on what we found in the papers we read the other day about Allie McCabe, that was Karen Reed's motion to compel. In Karen Reed's motion to compel, Aaron Rosenberg says, he's a material witness, and we need him, and we need his testimony, we need his deposition, because, I'm summarizing here, he testified that Allie McCabe drove him to 34 Fairview, and then he says he testified that Allie McCabe picked him up at 34 Fairview at 12:10, drove him straight home, and then drove herself straight home. And we have her Life 360 data, and that is not what her Life 360 data shows. Rosenberg said Allie's Life 360 data, which was provided to them through a phone extraction of Jennifer McCabe's phone, shows that Allie McCabe did not go to or from both 34 Fairview and Colin Albert's house at any point on January 29th of 2022. And there's a lot of people out there twisting themselves into pretzels. They should all become contortionists, trying to scream to the world that Life 360 data is just not accurate. And if you don't stop somewhere for 3 minutes, it won't register. It's so funny how in Canton, Massachusetts on January 29th of 2022, everything was out of whack. People were butt dialing people, and it was hanging up before voicemail even answered. Somebody's phone just mysteriously Googled Hoslong to dying cold at 2:27, but it wasn't really 2:27. It was really 6:23 or 6:24 a.m. And when you open that tab, it just goes back to some weird time. And then Celebrite all of a sudden took the timestamps off of everything. And now their software doesn't even show the timestamps. And yet a couple of other forensic programs still do, like Axiom and Magnet and others that I'm forgetting right now. And, you know, butt dials and curtain twitching out the window and seeing Karen's car at a time when she had already connected to the Wi-Fi at One Meadows. Deleted Google searches, deleted phone calls, deleted screenshots. Everything was just self-deleting. There were dead zones everywhere. It is like January 29th of 2022. Somebody should really look into see if there was any sort of like paranormal activity going on that evening, only in the area around 34 Fairview. Footage went missing. Library footage went missing that would have shown Allie McCabe driving by the library on her way to drive Colin home. Everything just disappeared. Sallyport videos on January 29th of 2022 became inverted. There were ghosts appearing in and out of the video. I'm telling you, has anybody looked into whether there was any paranormal activity going on January 29th of 2022 in and around the Canton area? Because everything went crazy that day. Maybe. I mean, I can't even believe it. UFOs and a full moon. Could anybody go over there with some like equipment from like back rooms or like, you know, the Blair Witch Project or something, or like, what's that other, all of those Hereditary, like all of those paranormal people. Maybe they should get in there with some equipment and see what happened. Here's what Tuxbury says in his motion, his opposition to having Colin Albert come in for a deposition. He says, Reed's motion is of a piece with her cynical, years-long campaign to scapegoat Colin and many others in order to deflect from her own culpability for Officer John O'Keefe's death. Reed's motion is littered with material misrepresentations, thoroughly debunked claims, cheap character attacks, and outright knowing falsehoods that have no place in court filings. Oh, kind of like your accusations of professional misconduct on like the 20th page of your motion, sir? Kind of like that. On the dispositive issue before this court, whether Reed is responsible for the death of Officer O'Keefe, Colin has virtually zero relevance. I'm sorry, am I in the twilight? Members, if you can't access your emojis on your phone because they were down for like a month, go into like your app store and update your YouTube app and then come back to it and they should be working. But we have an emoji for that. It's Twilight Zone emoji. Colin has virtually zero relevance about whether Karen Reed is responsible for the death of John O'Keefe. Well, here's the thing, sir. If John O'Keefe was not hit by a car and a car did not hit John O'Keefe, Karen Reed has nothing to do with it, and something else happened. And based upon all of the objectively or subjectively sus behavior of your clients, Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins, an argument could be made that all of this is relevant. They are accusing Karen Reed of pushing a false narrative that something else happened to John O'Keefe. And his deposition is absolutely relevant. He goes on to say it is undisputed that Colin was not present at 34 Fairview Road when Reed and Officer O'Keefe arrived in Reed's car. It's undisputed that Colin was not present when Karen and John O'Keefe arrived in Reed's car in front of the home. No, it is disputed, sir. It's absolutely 100% disputed. I don't care what your bogus metadata lists screenshot says. It is 100% disputed. And this is civil court, and all of that stuff is going to be admissible because I went back and I looked at the sidebar conversations during Allie McCabe's testimony in trial number 1. And that whole sidebar, when Judge Cannoni agreed to let that screenshot in, Yannetti argued everything: relevance, hearsay, not the best evidence, no metadata, and the judge still let it in. And in any other courtroom in the land, I submit to you that would not have ever been admitted into evidence, but she did it. In any event, whatever marginally relevant evidence Colin may possess does not justify the extraordinary burden imposed on him, a non-party, by the subpoena. Again, he's a plaintiff in another lawsuit that you represent him for. And so the judge is not going to buy these arguments. Although he did agree that they should narrow it a bit. Tuxbury says the subpoena is breathtaking in scope. Oh, I love a good Seinfeld reference. Breathtaking. The baby's breathtaking. It seeks documents and communications entirely unrelated to the death of Officer O'Keefe. It demands, among other things, all communications with no fewer than 12 individuals, including Colin's own mother and father, spanning over 4 years without any relevance to the death of Officer O'Keefe. These requests are not tailored to any discrete issue in this wrongful death action, or indeed any discrete issue at all, and are not curated to avoid undue burden upon a third party. Colin agreed to and did review his records for all communications with police officers pertaining to the investigation into the death of Officer O'Keefe and Reed's criminal trials, and all communications around January 29th, 2022 regarding the investigation into and death of Officer O'Keefe. Colin had none. He had no responsive communications except a text exchange with Allie McCabe, confirming that the two arranged for Allie to pick Colin up from 34 Fairview at 12:10 a.m. You know what's so funny about that screenshot of that text message? It doesn't say where to pick him up. It doesn't say, come get me at 34 Fairview. It doesn't say the address at all. That could have been from any time in history. It could have been proctored. Matt McCabe is in IT. You know, he's got a really big company. He's like pretty powerful, I heard, in the IT world. On January 29th of 2022, a text that Reed has had since 2023. Well, here's the thing also. It wasn't Colin Albert who provided that screenshot. Was it? Wasn't it either Jennifer McCabe or Chris Albert who provided that screenshot? So are you saying, Tuxbury, that it's still on Colin's phone, that text thread, that real genuine with metadata text thread still exists on Colin's phone? Is that what you're saying? You know what we saw the other day, too, in a motion filed by another queen of ours, Rosemary Scapiccio, in the Miles King case? She has an expert that is going to be able to recover deleted messages. She has an expert who is able to undelete deleted messages. Isn't that crazy? Who knew? So that's all he has. Not a text. He says it's a text exchange, not a screenshot of a text exchange. Colin had no responsive communications except a text exchange with Allie McCabe, confirming that the two arranged for Allie to pick Colin up from 34 Fairview at 12:10 a.m. on January 29th, 2022. Reed's demand for a deposition is equally flawed. On April 21, Reed served Colin, April 21, 2026, with a deposition subpoena for April 29th, commanding his appearance just 8 days later. Well, you know what's so funny is that the rule provides for 7 days. So your bolded and underlined font is misplaced here. Despite the short notice to a third-party witness, Colin was ready and able to appear for the deposition. However, Reed canceled Colin's deposition less than 48 hours prior and never issued a new subpoena. Right, because they said they were going to try and pick a new date because he didn't provide a responsive request to the documents that were asked for. Reed is moving to compel against a non-existent subpoena. Further, on May 19th of 2026, Colin's counsel learned that Colin had applied to enlist in the U.S. Army, and on May 20th, Colin's application was approved. Now, I think there's been what I think is some misreading of this sentence. All this says is that on May 19th, Colin's attorney learned that he had applied to enlist in the U.S. Army. That doesn't mean that he applied on the 19th. That means that that's when his attorneys found out. That's when somebody decided to call Tewksbury and say, oh, by the way, Colin applied to enlist in the Army. And then on the 20th, Colin's application was approved. So that's doesn't necessarily mean that's the date that he had applied to enlist. It means that that's when his attorney found out. Because, you know, even the judge said, your clients have an obligation to keep you apprised of their availability and their whereabouts. And, you know, your client has obligations too. Subpoenas need to mean something. And he just started his own lawsuit as a plaintiff, or they just dragged him in to their lawsuit as a plaintiff. Why they did that again to the child, I don't know. As a result of his enlistment, Colin was ordered to report to basic training outside of Massachusetts on June 2nd. That's a pretty quick turnaround. 12 days later, you're accepted, and then 12 days later, they're telling you you got to be at basic training. I mean, I don't know anything about it, so I don't know if that's customary or not. Maybe some of you working in, the enlistment office. I don't know. On the same day, May 20th, Colin's counsel informed Reed's counsel that if they intended to reschedule Colin's deposition after canceling it, Colin would have limited availability and offered the only dates on which Colin was available before this extended absence beyond the close of fact discovery. Reed's counsel declined those dates despite having 10 attorneys capable of taking his deposition, and the fact that Reed was supposedly ready to take his deposition on April 29th before she canceled it. This is so disingenuous. It really is. Instead, Reed, without indicating whether any of her other 9 counsel were available to take Colin's deposition prior to June 2nd, demanded that Colin, a third party in this lawsuit, sit for a deposition on dates that he said he would be unavailable. Then on May 22nd, Colin received a deposition subpoena from the plaintiff's counsel. Yes, Mark Diller's office. They had never subpoenaed him before, but all of a sudden, now Mark Diller's office served Colin Albert with a subpoena. After the plaintiff's counsel, Diller, learned of Colin's limited availability, scheduling his deposition for May 29th, 2026, which is one of the 2 days, by the way, I'm breaking from the document to tell you that Chaz Waters was not going to be in town. One of the 2 days that he was not going to be in town, Diller's like, oh yeah, that's the way we're going to do it. All counsel to this action except Reed attended Colin's deposition that day. I'm going to point out to you, I know we have a bunch of practicing attorneys in the chat. That's not the way it works. And I'm going to point out to you that you can't use it as a shield and a sword. Although he's claiming that he gave him 7 days notice. I think we're going to find out later that it was more like 6 days, and the rule says you have to give 7 days or more. Firewalk says, that's not how enlistment and leaving for boot camp works. Compounding these issues on June 3rd, 2026, Reed's counsel falsely told this court, without Colin's attorneys present, remember we watched this hearing, that Colin had refused to appear for the deposition. This was an unequivocal false statement that appears to have been designed to prejudice third-party Colin before this motion was even filed. This misrepresentation to the court, and here they go, in violation of Massachusetts Rule of Professional Conduct 3.3a, and Reed's refusal to genuinely remedy the misrepresentation further warrants denial of this motion as a sanction. Oh, Judge, we want you to spank Mr. Rosenberg because how dare he, without us even being present, declare in open court that Colin had refused to appear for a deposition. And they're throwing in the ethical rules. That's dirty, man. That's going low. That's really going low. Rather than accommodate a third-party witness's schedule. Oh, yeah, because he decided in the 11th hour that he was going to enlist in the Army and decided not to tell you. Reed filed this motion, a classic hallmark of discovery, designed to burden and harass rather than to obtain information. That's right. Everybody's out to get me. Everybody's out to burden and harass these people who were just normal moms and just witnesses in Karen Reed's 2 persecutions who witnessed nothing. And yet all people are doing are harassing them and burdening them. And that's what they want you to believe. And then he actually tried to spank Rosenberg by forcing him to file a letter with the court apologizing. And then the court was like, yeah, no, I don't accept letters and I'm striking this from the record. Indeed, the only gamesmanship at play is that of Reed and her counsel, who have misrepresented to this court the circumstances of their attempts to seek discovery from Colin. And here's their factual background. This is what Colin Albert's attorney says the factual background is. Court on the events of January 29th, 2022. On the evening of January 28th, 2022, Colin was a 17-year-old senior at Canton High School. That evening, he was at his aunt and uncle's house at 34 Fairview, celebrating his cousin Brian Albert Jr.'s birthday, who was also on leave from the military, along with his cousin's friends. Okay, was Beej on leave from the military? Anyone? Was Beej on leave from the military? I know that they have a son who's in the Marine Corps because they made a big deal about talking about Brian Albert showing Brian Higgins the pictures of his son in the Marines. And they also have a picture where they say Colin Albert's knuckles are in pristine condition that was taken on February 11th when one of their sons came home from the Army. But they're saying here, Brian Jr., whose birthday it was, Beej, was also on leave from the military. I think that that is incorrect, but I don't know for sure. But at least you think they could have gotten that right. Did Chris Albert not help proofread this for you? And look, Exhibit 1 is an affidavit of Colin Albert. At 11:55 p.m., Colin texted his close friend, Allie McCabe, to coordinate a ride home because he had a midnight curfew. Okay. Raise your hand if you think Colin Albert, who was 17 years old and openly drinking in front of his parents and others, had a midnight curfew on a Saturday night. Anyone? Or maybe it was a Friday night. I don't remember. Do you think that Colin Albert had a midnight curfew? They're very open, by the way, these families, about the drinking and driving. I mean, not drinking and driving, but the underage drinking seems to be perfectly acceptable in this little world of Canton, or this little pocket of Canton where paranormal activity occurred on January 29th of 2022. It's like everyone's just so, and Allie was driving because, you know, she was like the designated driver, and all of you were saying that, no way, you don't believe he had a curfew. And also Brian Jr. was not in the military. What are we doing here? I'm sorry, what is it that you say? Brian Albert Jr. was in the military and he was home on leave?
Hello?
Hello. Hello, I'm here.
Even Cardi B knows that's not true. She hasn't even been here for this. Allie texted back that she had to drive some other people home first at 11:55 p.m. At 12:10 a.m., Allie texted Colin to say that she was here Colin responded, okay. And then Colin left 34 Fairview at that time. See Colin Albert's affidavit as Exhibit 1. But I want to show you something about Exhibit 1. We're only on page 3. Hold on. Here's Exhibit 1. And here's what Exhibit 1 looks like when you download it from the court system. Really? Does anybody, if anybody has an actual copy of Colin's affidavit, I'm not zoomed in. This is how it is. This is how it was filed with the court. Can you email it to me at fanbase@mlittlelaw.com? This is Exhibit number 1. I downloaded this directly from court. And this is how they scanned in Colin Albert's affidavit. You can only read, I don't know, 4 words on each sentence. So we can't read Colin Albert's affidavit unless somebody's got a copy of it that we can actually read. And they want to pretend they're not playing games? Okay. I'll play. Nothing gets by me, as you know. So his affidavit is unreadable. We can't read it. It doesn't exist. Because, you know, he swore to it. When you sign an affidavit, you're swearing that what you said was the truth, and it just doesn't exist. Because that's how it was scanned into the court record, as I just showed you. But back to Colin having a midnight curfew. Also, Exhibit 2 is the text message exchange between Colin and Allie. Okay, let's look at that for those of you who might not have seen it. So here's what purports to be Exhibit 1, the affidavit of Colin, which, you know, we can read a couple words on each line. And apparently it goes, well, the first page is like half of paragraph 2. 3, 4, 5, 6. Page 2 is like goes up to starts at paragraph 16. And then there's a signature that looks like a scribble. And then here's Exhibit 2. Here, for those of you who haven't seen this screenshot of the text message thread, if you can come to your screen, now would be the time. This purports to be from Allie's point of view. Well, no, this would be from Colin's point of view, right? Because it says Allie at the top. So this would mean that this is from Colin's phone, and this is Colin texting with Allie. So maybe he does still have it on his phone. That would be interesting. This is what purports to be a text thread between Allie or someone named Allie and Colin Albert at 12:17 a.m. at the very, very top. We don't know what date this is, 12:17 a.m. We don't know if it's the day before. We don't know if it's a month before. Ha, ha, ha. Mikey's making me shotgun sorry. I got a lot of feelings about this. Remember that night he said he was at his friend Mikey's house before he went to 34 Fairview to say happy birthday to Beej, who apparently was, on leave from the service. And it's just interesting that it's about Mikey making me shotgun like a beer. A lot of you know what shotgunning a beer is. I don't know. That's the way I interpret it. But then underneath that text message, it says January 28th, 2022 at 11:54 p.m. You, just the letter U, can get me now. If easier, both of those texts purport to be from Colin's phone to Allie's phone at 11:54 p.m. Allie says, okay, I am driving people, PPL, home now at 11:55. At 11:55, Colin says, word, get me after, both at 11:55 p.m. At 11:55 p.m., Allie says, KK. And then at 12:10 a.m., she says, here, without a date change in the middle. I don't know if that means anything or not. And then Colin says, okay, at 12:10 a.m. And then the next text message thread between the two is not until February 20th, 2022 at 7:09 p.m. So something like, I don't know, a couple over 3 weeks later. We know from some of the testimony that we watched during the show I did on the cousins, the Tale of Two Cousins, that Brian Albert said he and Colin were communicating through Snapchat that night. Many people say that they communicate with people a bunch of different ways in the same night. Like they'll send an Instagram message, then a Snapchat message, then a text. I don't know. Kind of seemed a little odd to me, but maybe that's the generation. There's no metadata. This is just a screenshot of a text thread. Right. How did Allie know where to pick up Colin? That's a great point. And I'm saying that. I'm pointing that out too, because in the papers that we just read, he said there's a proof. There's proof that Colin told Allie to pick him up at 34 Fairview. And then, of course, on the February 20th, 2022, 7:09 p.m., Allie says on a Zoom, and then he says, are you, like the letters, are you going to Will's? Let's go. It's your birthday. You are birthday. We are drinking. 7:12 p.m. I don't know. Was Allie turning 17? They were both seniors in high school. They've known each other since birth. This proves nothing. On his way outside, this is again according to their facts. On his way outside, Colin saw his Aunt Nicole Albert. However, Colin never saw Reed or Officer O'Keefe. Instead, again referring to this affidavit that we can't read, instead, the undisputed evidence reflects that Reed had not left the waterfall Instead, the undisputed evidence reflects that Reed had not left the waterfall bar and grill until after Colin left 34 Fairview. Again, it's not undisputed. Allie drove Colin home, where Colin remained for the rest of the evening. Somebody said here, no chain of custody for these messages. More importantly, no authenticity. There's nothing to authenticate these messages. It's a screenshot provided by, I think, Chris Albert or Jennifer McCabe. I'm not really sure. No, it was Allie's birthday. It said it was Allie's birthday on February 20th. That was the text message between them. The next one on the screenshot was February 20th, saying that it was her birthday. So it wasn't the same. Also, on his way outside, Colin saw his Aunt Nicole Albert. Nicole Albert didn't mention seeing Allie in the driveway waiting for Colin, and Allie is their niece. Allie is the niece of Nicole Albert. Why wouldn't Allie come in and say happy birthday to her cousin Beej? Allie and Colin Albert are not cousins, but Allie and Brian Jr. are cousins. However, Colin never saw Reed or Officer O'Keefe, according to his affidavit. Instead, the undisputed evidence reflects that Reed had not left the waterfall bar and grill until after Colin left 34 Fairview. Oh, so it had to fit into the timeline. It had to fit into the timeline. So what time in the timeline did Karen leave the waterfall? Somebody must know this from looking at the, I know you have the surveillance video from the waterfall memorized. What time was it stamped, Emily C., in the waterfall that Karen Reed left? It had to fit into the timeline. Do you see? Do you see why it had to be 12:10? Maybe Zoe knows. People are saying like 12:13, 12:14. Right. It had to fit the timeline. Well, now you're telling us everything. The undisputed evidence reflects that Reed had not left the waterfall bar and grill until after Colin left 34 Fairview. It had, not Chris Albert. I want to know when Karen Reed left. Not Chris Albert. Karen left before Chris Albert. I think it was 12:13, 12:14. Of course, Colin had to leave 34 Fairview at 12:10. What time does the video show Brian and Nicole leaving? I can't believe that it is. Tomorrow, it'll be 1 year to the day since Karen Reed was finally acquitted. It has been a year and a half that I've been talking, 2 years, 2.5 years, 2.5 years I've been talking about this case since January 2024. We're still talking about it. Emily says Chris left at 12:14. Karen and John left at least 5 minutes before, but didn't park in the waterfall parking lot, so they had a little walk to her car. Poe Hunter says 12:11 video Karen leaving. So of course Colin had to leave at 12:10. Don't you see? It must fit into the timeline. Wow. Allie drove Colin home, where Colin remained for the rest of the evening. Well, according to the original filing, the motion to compel, that is not what Allie's Life 360 data shows. According to the filing by Rosenberg, Allie's Life 360 data shows that she never went to 34 Fairview, to or fro, or Colin's house on January 29, 2022 at all. And it's so funny when they want to use it as a shield and a sword, because in one of Jennifer McCabe's original, witness statements, if you want to call it that she gave to Proctor or Buchanan or Kathleen Prince or whoever she gave it to, she whipped out her phone and she showed them her Life 360 data to prove when Karen got to her house, when they left her house. So you can't use it as a shield and a sword. And you can't say that Jennifer McCabe's phone's Life 360 data is accurate when it comes to talking about where Karen Reed was and what time Karen Reed showed up at her house and what time they got to One Meadows and what time they got to 34 Fairview. But it's not accurate as far as Allie McCabe goes, just a couple hours earlier. Oh, here it is. B, the defamation campaign against Colin. It's so funny, counselor. As you were reminded by the judge, you represent Colin Albert as a plaintiff in a defamation case, but this case, you say, has nothing to do with the defamation case, and that's why you say Colin Albert shouldn't be necessary in the O'Keefe versus Reed case to come for a deposition. But here you are using it as a shield now. As a sword, saying that here's all about the defamation campaign against Colin. There's a whole campaign, and wait till you see who they quote in here that has been defaming Colin Albert. In addition to the people that they sued, there's some people on Twitter that are being also accused of defamation of Colin Albert by responding to Aidan Carney's tweets. Here you go. Here's the whole defamation campaign against Colin, because it doesn't, as if it belongs in these papers. The initial aftermath of Officer O'Keefe's death largely did not impact Colin. Why do you think that is? Because everyone hid him from the police reports, even though we found out yesterday, or whatever day was my last stream, that Michael Proctor has notes that indicate that Colin Albert was in the house. Michael Proctor chose not to put Colin Albert's name in any police reports. Of course, it didn't impact him because nobody knew he was there. None of these people were interviewed until something like 18 months later. And when I say none of them, I mean not the people who actually live in the house, the adults. I'm talking about the kids who were there for Beej's birthday. Colin was not present and was not a witness. Okay, then how can you charge Aidan Carney with witness intimidation? He also barely knew Officer O'Keefe, who lived in Colin's former neighborhood. Following the initial shock. Okay, what initial shock? The initial shock of what? Following the initial shock of what? Of the murder of a Boston police officer that you barely knew? And everyone hid you from the location because there were other people mentioned in police reports. I don't know who their names, Emily Fabiano, Catherine Duty. I don't know why I know these names, but they weren't there even when like Nicole and Brian Albert came back to the house, but their names were mentioned in police reports, but Colin's never was. So what initial shock is it that you're exactly talking about? You're saying he barely knew John O'Keefe. But following the initial shock, Colin's high school life returned to normal as he prepared for post-high school plans at Bridgewater State University and then started freshman year there. That all changed on April 12th of 2023 when Reed and her counsel publicly and falsely, this is italicized and bolded, accused Colin of being responsible for Officer O'Keefe's death. Reed had no actual evidence to support that claim. Instead, months later, her counsel, attorney David Yannetti, would claim an individual called with a tip and identified Colin as his uncle as the responsible parties. That individual was eventually identified as Steve Scanlon, a Canton resident who previously admitted that he had no personal knowledge of the events of January 29th of 2022, and that prior to meeting with Yannetti, he had never even heard of Colin Albert. See Exhibit 3, which is an investigative memo from Yuri Buchanan to Brian Tully regarding an interview with Scanlon. Okay, hold on a second. Let's take that back. April 12th, 2023. That all changed for Colin Albert when Karen Reed and her counsel publicly and falsely accused Colin of being responsible for Officer O'Keefe's death. Guess what that was? That was before Aidan Carney ever published any articles in his, online blog about Colin Albert. Okay. Let's look at Exhibit 3 for a moment. We'll go back to it when we get to it. But Exhibit 3 is a MSP on MSP letterhead. It's dated October 17th of 2023. So they waited 6 months. They waited 6 months to try and get a hold of Steve Scanlon, even though this information they're saying became public in April. And look how quick they turned this report around. They interview Scanlon October 16th of 2023. They write the report right away, the very next day. They didn't wait 500 days or however long. They waited during some of the investigative materials into the murder of a Boston police officer. Oh, no. But when you want to clear Colin Albert, you get right on it. You get right on it and you draft that report up butt quick. So we're going to read this afterwards, but it says Lieutenant Fanning and Buchanan went to interview Stephen Scanlon with his attorney, Tim Flaherty. So Scanlon lawyered up. And Yuri and Fanning are the ones who went and interviewed him in October of 2023, which is around the same time Aidan Carney was indicted on witness intimidation charges, right? Right? Isn't that when he was, what was the date? And he says it every day in his Bus Stop Live. The date that he was arrested by Fanning at his kid's bus stop. What was the date? October what? 2023. Somebody knows the date. And that's just around the same time that they're interviewing October 4th. I don't know. People are saying October 11th, October 14th. It's all around the same time that they're all of a sudden deciding to interview Scanlon. And much of this report has to do with Aidan Carney. Hold on. I just don't want to make sure that I'm not conflating this with someone else. Here it is. Paragraph 8. Stephen was asked if he ever had a phone conversation with Aidan Carney and whether or not the conversation was recorded by either of them. Again, they were looking for more charges on Aidan. That's the only reason that they went to interview Scanlon. Are you seeing what's going on here? Are you seeing how powerful these people might be? We'll read this when we get to it. October 11th, 2023. They were looking for more charges on Aidan. It's the only reason they went and did that. Can't you get him to stop blogging about us? 10/11/2023. This is scary. I mean, this is scary because if the law can be weaponized against people like Karen Reed and Aidan Carney, it can also be weaponized against you. Just like it was weaponized against Richard Schiffer for putting little tiny plastic rubber ducks around town. One or two of them outside of D&E Pizza with little stickers on the bottom that said Colin did it or IYKYK. And the 36-page police report from Canton PD that arose from that investigation into rubber duckies, which also was around the same time. I have it pulled up because I wanted to talk about that today too. also in October of 2023. They really, really, really wanted to shut Aiden Carney up. So much so that they continued to frame him until he was thrown in jail for 60 days in December of 2023 because he was effective. Thank you. It was October 11th. Thank you, Lucy. Do you see what's going on here? And I thank you, Jimbo Tuxbury, for connecting some more dots for us, because it's all inextricably intertwined. Further, days after Reed's April 12th court filings, oh, here it is. And in coordination with Reed, blogger Aiden Carney published his blog in which he accused, without any supporting evidence, Colin of killing Officer O'Keefe. The centerpiece of Reed and Carney's false accusations against Colin was a Facebook photo taken a month after Officer O'Keefe's death, showing Colin had scraped his knuckles on his right hand. Okay, well, I'm not a fighter. I'm a lover, not a fighter. I'm a lover, not a fighter. First of all, it wasn't taken a month after. I think they're saying it was taken February 11th, which would be 30 days, how September, April, June. 13 days, 2 weeks after. Wait a second. No, wait. A Facebook photo taken a month after showing Colin had scraped his knuckles on his right hand. Okay, so that's the one from that was taken at the bar that show his knuckles all busted up. Okay. I don't know the exact date of that one. And I'm also a lover, not a fighter. So I don't know how long it would take for knuckles to heal after, if somebody were to beat the bejesus out of somebody like with their right hand, and you were barehanded or bare-fisted. This is a hypothetical now. Would your knuckles look like that? And if yes, how long would it take for them to heal? That's what I need to know from some fighters in the chat. Well, Z Brew fan says it takes several weeks for the knuckles to completely heal, especially if the skin is broken. Let me know if you know. Andrea could answer that. Yeah, I don't have time to text her right now while I'm in the middle of a stream with you. There's got to be some fighters in the chat, right? All right, moving on. 3 to 4 weeks, people are saying. Thank you, Elizabeth. Hoslong. I'm sorry. Thank you. Thank you. Like your dog Morris says, correction. Hoslong would it take for them to heal? Yes, Hoslong. Okay. Reed's reliance on his photograph in the motion to imply that Colin killed Officer O'Keefe is a misrepresentation. Yeah, or a question of fact for a jury. Indeed, prior to her first criminal trial, Reed has possessed photographs of Colin taken after Officer O'Keefe's death and prior to the Facebook photo that clearly show no scrapes on Colin's knuckles or injuries to his knuckles. For the court's convenience, samples of such photos, with timestamps, unlike all of the other evidence in the trial, are displayed below. And here's some photos that I can't really see, but I think what they purport to show is Colin with Nicole Albert, this one on the right anyway. And I think the date of these photos is supposed to be, please don't dox people's birthdays. I would appreciate that. That's just so not cool. It purports to be taken, I think, on February 11th when there was some sort of party. I don't know what metadata came with this. I don't know if they've been run through the Colleen Crawford software. I don't know where they came from, or if they've even been authenticated. But it says February. I don't know. It's hard. You really can't read what this says. I have no idea what it says. In other words, as Reed well knows, the evidence she has submitted to this court to lamely suggest, what are we, 12? that Colin may have sustained injuries to his knuckles in connection with the death of Officer O'Keefe could not possibly support her theory because earlier photographs show the absence of any injury. Okay, then why hide his presence at the house? Why? Lamely suggest? I mean, this is a little ad hominem, don't you think? What are we, 12? Bang, bang. Advantage boys, bang, bang. The impact of Reed's continued attacks on Colin's character and reputation has been catastrophic. While such is the subject of the pending defamation action brought by Colin against Reed and others, it is noteworthy for purposes of this court's consideration of the motion. It really hasn't. Since Reed conjured up, oh, we're conjuring now. It's the Conjuring. I told you there was paranormal activity that day. Since Reed conjured up the baseless allegations that Colin was somehow involved in the death of Officer O'Keefe, Colin has had to drop out of college and has been continually harassed and defamed online. Dozens of individuals have confronted Colin both at home and at work, accusing him of being involved in a murder, which has caused him to fear for his overall safety on a daily basis. And that is terrible. And I do not suggest that anybody do that whatsoever. I'm just here reading the court documents, which they're telling us in the court documents that this is what is happening to him. Nevertheless, Reed continues, even in the present motion, to push a baseless fantasy. Now it's a fantasy, a baseless fantasy that Colin was somehow involved in the death of Officer O'Keefe, even though Reed and her counsel know their claims against Colin are patently false. No, they believe them to be true, which is why you're suing them for defamation. I think he did work. Did he work at the pizzeria? I think he did work at the pizzeria because remember the night of the T-Rex arms when Aidan Carney and Will DeGlaire were outside D&E Pizza, another witness intimidation charge that Aidan Carney is facing. I think part of the allegations were that Colin was home watching the video or Colin was cleaning up the pizzeria or something. And that too scared him. So I think that he did work at the pizzeria at some point. But again, they're calling this a baseless fantasy. And it was lamely suggested, the baseless fantasy. And that's just the very small portion of the defamation campaign against Colin, because they say that these photographs are proof that Colin didn't beat anybody up, especially not John O'Keefe on January 29th, 2022, because these photos. Reed's April 21, 2026 subpoena. And then it goes on to say that the motion asserts that on February 11th, Karen's attorney properly served a notice to take the deposition of Colin for April 29th. That assertion is misleading. Reed fails to disclose that such notice was never sent to Colin or his counsel. Well, that's not a proper notice then. If they didn't send it to Colin or his counsel, that's not a proper notice. I would agree with that. Instead, on April 21, more than 2 months after Reed's attorney issued a notice of deposition to counsel of record, well, that would be so that they could put it in their calendar, the attorneys. Reed's counsel personally served Colin with the subpoena at home, commanding him to produce a trove of documents within 6 days and to attend a deposition within 8 days. Okay, well, again, that's okay because the rule only requires 7 days notice. On April 27th, undersigned counsel served responses and objections to the document requests obtained in the subpoena based upon, among other things, the requests over breadth, vagueness, ambiguity. At no point did Colin or his counsel object to the April 29th, 2026 deposition date. Indeed, Mr. Albert was ready, willing, and able to attend the deposition on April 29th. Okay, if he was ready, willing, and able, then why didn't he just turn over the documents that he was asked to bring? And so after that, on April 27th, Karen's attorneys requested dates and times to meet and confer, because that's what they're supposed to do, meet and confer, try to work it out so you don't have to waste the court's time. And then in that email, Karen's attorneys wrote, under the circumstances, it makes sense to take Colin's deposition after all the responsive documents are produced, like we're going to reschedule. Undersigned counsel promptly responded, seeking clarification regarding Colin's deposition. To clarify, are you canceling the deposition scheduled for April 29th? Reed's counsel then responded in relevant part, confirmed that Wednesday's deposition will be rescheduled to a different date, right? Rescheduled. It's not canceling, like calling it off altogether. It's called an adjournment. Happens all the time, especially when they don't have the proper documents. On April 28th, undersigned counsel conferred with counsel for Reed regarding the scope of the request, trying to narrow it down, etc. At the conference, undersigned counsel inquired as to why the subpoena was served on Colin, a non-party with such little compliance time. Counsel for Reed did not provide an explanation and simply cited Massachusetts Rules 45, which permits a subpoena to be served with a 7-day compliance time. I just want to point out that this opposition to the motion on behalf of Colin Albert is, with exhibits, 109 pages long. How much money do you think Colin Albert had to pay this attorney to oppose this motion? Because, again, this is not the defamation case. He's a non-party. How much money do you think it cost Colin Albert to oppose this so fiercely instead of just showing up to a deposition and providing the documents that they're asking for? Coconut cupcake. Oh, I love coconut cupcake. I love coconut so much. It says new songs to the playlist, Crumbling Down. I think that was one of the very first songs that we added to the Spotify playlist here. That is one of the first. I love coconut. The amount of money that was spent on this, instead of just trying to agree on a date when he could provide all the stuff and show up for a deposition, I would agree with you that maybe the plaintiff's case is on contingency, but this is not part of, this is outside the scope. Astro Stephanie, this is outside the scope of the plaintiff's case. This is different. This is in a different lawsuit. He's being subpoenaed as a non-party. And so I don't think that this would fall under the contingency. And I don't even know if they've taken it on contingency. And somebody, Goth Boy, says, cost Colin nothing. They're using the $250K from the GoFundMe. Right. Oh, so sad. Jimbo's crying in court about it. It's expensive, says Sheila. Look at Nona to 3, gifting 5 memberships. You're amazing. Thank you so much. And Friend of Dog gifted 10 memberships. That's 15 new members today. They are randomly gifted by YouTube. I have nothing to do with it. But thank you so much. You guys are so incredibly generous. And Darlene gifted 5 memberships. She's amazing too. There's at least 20 new members. Check out the member emojis down below. Just go into your chat box on your phone and click on the little smiley face next to it. And you can see all the emojis that we have curated for this and other, mostly this trial, the Karen Reed stuff. And Hamnesia Boot Camp Hulda is here. She gifted a membership too. I'll get to the rest of these super chats in a little bit. And then there's a lot of squabbling. How dare they ask for over 4 years of communication between Colin and his parents without narrowing it? And they go on for a couple of pages about that, how it's overly broad. And we were trying to reach an agreement, but then we just couldn't. And now I'm going to accuse them of ethical violations. And then they go back and forth with proposals and counter proposals. And then on May 5th of 2026, counsel for Reed served 6 additional subpoenas on non-parties. Allie McCabe, Jennifer McCabe, Matthew McCabe, and Brian Albert, Nicole Albert, and Brian Higgins. Notwithstanding, that's in Exhibit 6, notwithstanding the concerns raised in Colin's responses and objections and during the April 28th 9C conference, these additional non-party subpoenas were identical to the objected to subpoena originally served on Colin. Okay, so what? Here's the problem. It's just part of the problem is that Tuxbury represents all these people, all of them. And it's a clear conflict, as you can see. As you can see, if it wasn't clear to you to begin with, it's getting more clear as time goes by, right? At this point, it became apparent that Reed was not seeking meaningful discovery in an effort to locate relevant information related to the wrongful death case, but was using her subpoena power to obtain over 4 years of unrelated communications in an ongoing effort to harass and retaliate against individuals who had the audacity to give information to the police and testify at trial. Yes, they had the audacity to give information to the police and testify at trial. This guy is so hyperbolic. It's funny. Really? Really? Karma is a patient gangster. Oh, thank you. Frisvold 85. Karma is a patient gangster. Oh, I like it. Karma knows your address. Remember, we were having a contest to see who could come up with the best design for a T-shirt that says "Karma knows your address," and somewhere have an Attorney Melanie little logo on it. And I've received a lot of submissions. I have to go through them all, and then we will vote. Maybe we'll do a members only for that. But I like that. Karma is a patient gangster. Iced Coffee says, I'm stating the obvious, I know, but if they're all innocent and it was Karen Reed, etc., as they present and defend. Thus, since Reed's team refused to do so, it became incumbent on counsel for the Alberts, the McCabe's, and Mr. Higgins to propose reasonable topics of communications that they believe to be within the scope presented in this case. Okay, yeah, but you are counsel for all of them. It's not like you have to get a million attorneys involved. You are them. Your firm represents all of them. And then it says, following receipt of the May 5th subpoenas, counsel for the Alberts, the McCabe's, and Mr. Higgins conferred internally to do so. Right, internally, because you represent all of them. Oops. Oops. And then here it is. Section D, Colin Albert joins the United States Army. On May 19th, 2026, Colin informed counsel that he would likely be joining the U.S. Army, and that if so, he would be forced to leave Massachusetts for initial and basic training beginning on June 2nd, and that he would be gone until the fall of 2026. See Exhibit 1 and paragraph 12. Well, we can't because we don't have a clean copy of that affidavit of Colin Albert that you purport to attach because, you know, copying is hard. Copying is hard. Oh, please. Then just one day later, on October 20th of 2026, Colin confirmed that such would be the case and that his situation would limit his access to phone or email communication. The same day, counsel for Colin notified counsel for Reed of Colin's sudden scheduling conflicts, proposed 2 dates for Colin's deposition, May 28th and May 29th, that were within the same compliance period of the notice given to Colin by Reed's original April 21 subpoena. But I thought you're saying that the subpoena was invalid or ineffective. You can't have it both ways. Colin originally requested that the circumstances of his unavailability remain private, given the profound levels of harassment and intimidation that he has previously been subjected to from Reed, non-party Aidan Carney, and their following, including dozens of instances of third parties showing up to his home, workplace, and school. I don't think people should do that. I don't think you should show up to his home, to his workplace, to his school. But you're going to see in the exhibit all the people that they're calling out who commented on Twitter that they're also trying to silence. But it's the Worldwide Privacy Tour. And for those of you who are not familiar with the South Park episode, season 26, episode 2, it's up there in the corner. I've got some bigger photos. It says, respect our privacy. We want privacy. They move in across the street from Colin. And across the street from Colin. And the house kind of looks like 34 Fairview, across the street from Kyle. And all they want is their privacy. And Harry's out playing the drums at all times of night. Hold on. I'll pull it up for you so you can see it. Bigger. Because whether you like my chit chat or not, I don't really care. Some people come in the comments, they're like, too much chit chat. I'm here to talk about Karen Reed. I'm like, okay, I'm here to engage with my audience. If you don't like it, there's about a million other channels that you can go and watch on the tubes of you. I mean, is it that some people are just not happy unless they're complaining all the freaking time? I think that's what it is. I'm pretty sure. So here, oh, please. I mean, he just wants his privacy. That's all he wants, right? There's an island for these people? Oh, yes, there is. Hold on. Here is the South Park episode I'm referencing. Stop looking at us. We want our privacy. We want our privacy. We want our privacy. Everyone hit the like button. This is your reminder, your little break and reminder to hit the like button. Wait, I think I can do it this way. Hold on. Here it is. And this is when they move into across the street from Kyle. Look, leave us alone. Respect our privacy. Respect our privacy. Go away. Go away. I mean, it could be like 34 Fairview, right? And then there they are, Harry and Meghan, looking out the window. Look, they're curtain twitching, but they want their privacy. Respect our privacy. Respect our privacy. Go away. Go away. The Worldwide Privacy Tour. And there they are with their signs. Oops. Oh, by the way, there is a debate tonight for the Norfolk County DA's race. It is tonight from 7 to 9 p.m. There is a new location. It's at Medway High School Auditorium, 88 Summer Street in Medway. I guess Adam Deitch will be there, and all of the other candidates who are running, all 7 of them who are running for Norfolk County DA tonight, 7 to 9 p.m. I don't know if it's going to be broadcast anywhere, but, go for it. If you live in Norfolk County, get on over. And then here they are getting on their private planes with their signs. Stop looking at us. We want our privacy. Stop looking at us. We want our privacy. Stop. I don't know if they're airing it on TV. I don't know if anybody knows. Canton Community TV usually does things like that. And I don't rightly know if they're going to be there tonight, but maybe somebody's going to tape it on a delay. I mean, tape it and then run it on a delay. Okay, so Colin really wanted everything to remain private because of all the harassment that he has received. And all of these people showing up to his home, workplace, and school, which I completely have a big problem with. Don't do it. Don't do it. To protect his best interests and safety, Colin's counsel provided unqualified what? To protect the best interests, his best interest and safety, Colin's counsel provided unqualified representations of his unavailability without mentioning that it was to join the Army, instead stating that it was work-related and that this was something Colin's counsel had just learned as well. Okay, so you lied. It has nothing to do with his work. You were just trying to protect his privacy. I don't know. I just think that his privacy train might have ended when the day that he served a lawsuit for defamation against Karen Reed and Aidan Carney. I mean, I don't know. It's like the Afro Man effect, right? This is why we have an Afro Man cupcake made lovingly for us by Charissa. Because there's Afro Man. You know the lore behind Afro Man. It's like the Streisand effect. It's now the Afro Man effect. And that's going to be a problem. Everyone, you have no privacy anymore. You filed a defamation case. It is public. Everyone's talking about it. Footnote 1, which reads, oh, here we go. We're going to get to this exhibit. Colin's concerns about public disclosure were well-founded because notwithstanding these reasonable efforts, it became public within hours of Colin's swearing in ceremony that Colin had joined the military. Well, because the swearing in ceremony was broadcast on the internet. I don't even know who posted that. Was it a member of his family? Like, you can't say you want privacy and then film Colin's swearing in ceremony and then post it on the internet. There's a video of it. Right? How did it become public? It wasn't Aiden Carney who went there and filmed it. Oh, here it is. Indeed, non-party Aiden Carney published a video disclosing Colin's decision to join the army and publicly announcing that Colin was a big fat P word and that he joined the army to avoid going to jail. See Turtle Boy Live, episode 882. June 2nd, 2026. I don't know. Maybe Aiden Carney's a good investigative journalist and he just found it. He didn't make it up. There's video there. Wow. In the same May 20th, 2026 email, counsel for Colin relayed a proposed scope of potentially relevant communications to the wrongful death action. And here's all the things that we agreed that it would be relevant and that we could give you. But, we did also say in good faith that Colin had undertaken reasonable efforts in the prior weeks to locate communications responsive to those categories, but with the exception of a singular text exchange, no other responsive communications existed. Footnote 2. Okay, so he did a search. He searched his phone. He searched his Snapchat messages. He searched his WhatsApp messages, his Instagram DMs, his Twitter DMs, all the socials, his Facebook Messenger, everything, Signal. And the only thing that he found was a singular text exchange. Prove it. Prove it's real. Prove it's real. Show the metadata. Get an official phone extraction and prove that that text thread is real, because a lot of people think it's not. Footnote 2. And then it says no other responsive communications existed. Footnote 2. Which says the efforts undertaken to locate these communications are described in detail in the affidavit of Colin Alberts, see Exhibit 1. Again, we don't have it. We can't access Exhibit 1. Let me see if it's in my inbox. Tiff, you're really good at this stuff. You're always helping me. Anybody have a clean copy? It's not in my inbox yet. It is not. Okay. I mean, who's hiding things now? Counsel stated that it believed Reed was already in possession of that text exchange. Again, there's no metadata. In a real court of law, that would never be admissible. Never. You can't authenticate it. It's not the best evidence. Judge Canoni was wrong when she let that in. She said, oh, it doesn't go to its admissibility. It just goes to the weight that the jury can give it. Indeed, she refers to it in the motion itself, but that Colin would be willing to produce it to her to the extent that understanding was mistaken, right? She's already got it, but we'll give it to you if we are mistaken that you already have it. Despite giving Colin the exact same amount of notice for his original deposition, counsel for Reed declined to accept Colin's offer to be deposed on May 28th or 29th. Oh, isn't that so nice of you? You offered. Instead, counsel for Reed stated that the one lawyer that Reed designated to take Colin's deposition, attorney Chaz Waters, was out of state on those dates, in quotes, as if he's lying, out of state. If he's the one doing it and he's the one who's prepped for it, I don't care how many lawyers she has. Only 2 days. Oh, please. They only give 2 days before he's got to go to boot camp. Instead, counsel for Reed stated that the one lawyer, right, he's not going to be there. It says, Reed's counsel, okay, Reed's counsel did not describe the circumstances of the designated lawyer's unavailability or explain why any of the other 9 lawyers representing Ms. Reed could not take Colin's deposition. I'm sorry. Do they work for you, sir? Do they work for you, sir? Do they owe you an explanation? You lied and said Colin had a work-related thing that made him unavailable. And you're miffed that they're not giving you an acceptable explanation, but to say he's going to be out of state, that's not good enough for you, sir? Okay. See how snarky, like when I say snarky, usually you guys are the snark tank. So like, to me, that's like more of a compliment. This is just rude and unprofessional. And, as Proctor would say, regrettable. Reed never identified whether attorneys Rosenberg, Seligson, or Jackson, who extensively questioned Colin during Reed's first criminal trial, were unavailable. Guess what? Alan Jackson's also in California, so involved with Alan Jackson comes travel expenses and hotel expenses, etc. But they owe you an explanation. Oh, please. On May 21st, Colin's counsel also informed plaintiff's counsel regarding Colin's sudden availability issues. With no deposition scheduled prior to Colin's departure, on May 22nd, the plaintiffs, meaning Mark Diller's office, served a subpoena on Colin through his counsel. Oh, so now you're changing the date. So now it's May 22nd. Commanding his attendance at a deposition on May 28th. Was it really commanding him? Because that's only 6 days notice. That's only 6 days notice. You didn't like 8 days notice when it was Karen Reed's team that was noticing him. But you're totally cool with 6 days notice when it comes to, wink, wink, say no more. Wink, wink, say no more. Mark Diller and all. See Exhibit 7. Bound by the subpoena. On May 28th, Mr. Albert was deposed. Oh, I see. Okay, so let me get this straight. Your client is only bound by a subpoena when it's served on him by the plaintiff in this action, who didn't demand he produce jack shit? Is that what you're saying? Oh, so your client is bound by a subpoena when it's less than 7 days notice, which is, not proper under the rules that you keep citing when it comes from Diller, but not when it comes from Karen Reed's team. Come on, man. This is so gross. It's so gross. Bound by the subpoena on May 28th, Mr. Albert was deposed, where he testified truthfully under oath. Well, I don't know. You better be careful there regarding the events of January 29th, 2022, in addition to other issues. Oh, what kind of softball questions did Mark Diller ask him? Because here's the thing. Mark Diller's in a bit of a pickle. It's a Diller pickle. Mark Diller is in a bit of a Diller pickle because Mark Diller did not sue Colin Albert or Brian Albert or Jennifer McCabe or Brian Higgins on behalf of his clients, the O'Keefes. And so Mark Diller is putting all of his pickles into one basket, hoping that maybe by some stretch of the imagination and fantasy, a jury, if it gets that far, in this case, will determine that John O'Keefe was hit by a car. Because if that's not what they determine, your clients are shit out of luck because you didn't sue any of the other people and the statute of limitations is over. It's too late. It's too late. Which in my mind from the beginning has been a recipe for legal malpractice, but he doesn't seem to care about it because now they're coordinating Colin Albert's deposition. Right. Here's the deposition, according to Tom just saying. Diller, did you leave at 12:10? Yes. Okay, we're all set. We're all set. You're free to go, Mr. Albert. I mean, it's a CYA. It's a cover your ass sort of thing, right? maybe, in my opinion. Counsel for the plaintiffs, as well as counsel for defendant McCarthy's questioned Colin. Great. Colin, you didn't see John O'Keefe come into the house, did you? Nope. Colin, you left 34 Fairview at 12:10, didn't you? Yep. Okay, Colin. That's all I have. That's the shortest transcript ever. Ever. Counsel for defendant Waterfall was in attendance by Zoom, but did not ask any questions. They're like, this is ridiculous. What is it that we say we do here? None of the 10 lawyers for Ms. Reed chose to attend Colin's deposition, even though, upon the undersigned's information and belief, another witness deposition was previously scheduled for that day, but canceled. Oh, wait a second. So how was Diller or any of the other defense counsel going to appear for a different deposition if there was supposed to be a different deposition that day? Why would Diller subpoena Colin to come for that day if he already had another one on the books for another witness in this case? This stinks. This stinks. It stinks to high heaven. It stinks to high heaven. I'm sorry, Tammy. Tammy Tebow says I'm in a crowd alone right now, and I just laughed out loud. People just looked at me. Further, it gets better. Further, the deposition occurred in the same building as in she and Finney's office. Okay, so it doesn't mean they have to show up to a deposition with less than 7 days notice under the rules in which the client or the witness did not provide any of the demanded information needed to properly question him. And you can bet your ass too that they probably have so much stuff from Proctor's phone extraction that may involve Colin. They've already got it. A good lawyer never asks a question he or she doesn't know the answer to. It was in the same building. They didn't even show up. Oh, that's what all those idiots are saying over there. All the people who think John O'Keefe got hit by a car and or are being paid by the PR team, the PR firm for the Alberts and McCabe's, didn't even show up and it was in the same building. Okay. Okay. Again, hit the like button. Hold on a second. James Joe, I don't know who you are, but please do not come in here and try and convert people to your religion. We don't do that. We don't do that here. I don't know. Maybe that's okay where you come from, but oops, hold on. Caroline, I did the wrong thing. Wait a second. Caroline, I deeply apologize. I clicked on you by accident. It was supposed to be someone else. If you can't chat, that's totally my fault. I don't know if anybody else can fix it. But somebody else was supposed to take a little time out. Somebody who was trying to convert us to their religion. Hold on. Here we worship due process and justice. Thank you very much. Thank you very much, Becky. And then it gets to Section E, the June 3rd conference, status conference. During a June 3rd status conference, in this matter, counsel for Reed, Attorney Rosenberg, accused the undersigned, as well as Colin, Brian, and Nicole Albert, the McCabe's, and Mr. Higgins of playing games with the wrongful death action discovery schedule. Playing games at the June 3rd conference. At no point prior to making the accusation to the court that these non-parties were playing games did Reed's counsel undertake any effort to inquire about the schedules of these non-parties or their counsel so that all parties could come to mutually agreed upon deposition dates. I think he's learned through experience that these people are just, they don't agree. Everything, the judge has to rule on everything because nobody can agree. Everyone's bobbing and weaving and bobbing and weaving and bobbing and weaving. I stand with Mel. My email address is in the show notes of this video every single time. Fanbase@mlittlelaw.com. Indeed, it appears that this courtesy was only given to the other witnesses in this case. And then he goes on and on and on about this June 3rd status conference. And that Rosenberg said Colin Albert refused to appear for a deposition, refused to produce documents. And then they link the trial channel. There, shout out to trial channel. They link that hearing from June 3rd. And go on and on and on saying that this was a lie. They're disparaging me. How dare they disparage me? That this, it says, that proposition made in open court and to a live streamed audience of hundreds. Are you talking about the Zoom? Because Trial Channel did not live stream that. No one's allowed to live stream it. Trial Channel puts it up after the fact and people watch it, but it wasn't, if it was live streamed to hundreds, that was hundreds of people watching the Zoom, maybe. But don't bring Trial Channel into it and then also accuse her of like violating the court rules. Because if I'm not mistaken, Trial Channel did not live stream it. Nobody did, because nobody's allowed to unless you get special permission from the court. That's why we had to do it on delay. Except today, CBS was doing it. So we were able to live stream CBS's stream. See how that works. And there was no Zoom feed today. Because if you're talking about how many people watched that hearing altogether, I would say it's tens of thousands, not hundreds. So now he's embarrassed because he's saying Colin Albert refused to appear, refused to produce documents. Is that embarrassing you, counselor, or your client? Colin never refused to appear for a deposition. Ms. Reed's counsel canceled his original deposition. No, they wanted to reschedule it after he properly produced. I'm fighting with it. You can't fix stupid. So I can't even, you know what I'm going to say. Then Colin sat for a deposition in this case on May 28th, 2026, and Reed's counsel refused to appear. Okay, again, keep pissing at each other. It's not going to go over well with this judge. And this judge said, no, you're going to come back here on Monday. You're going to come back here with dates that he's going to appear. I don't care if you have to get him out of boot camp or what. The patent misrepresentations regarding Colin refusing to appear for a deposition sparked immediate online attacks and defamation against Colin. Oh, more defamation. Are you gonna be adding more people to your lawsuit? Because they keep threatening to add me to it as well. Well, they don't, but their minions do. Because I read court documents. Don't put all this in your court documents if you don't want people to read them. We can fix stupid. It's just going to hurt. Well done, Megan, with 8 letters. Listen to what they say. Following that misrepresentation, Colin, as well as other non-parties, were harassed, defamed, and ridiculed by dozens on various social media platforms, falsely claiming that Colin refused to appear for the deposition. This was entirely predictable. It's entirely predictable. Are you going to sue Attorney Rosenberg now for defamation too? We want our privacy. We want our privacy. And then they go into their attempts to meet and confer. I tried so hard. I really tried. I told Rosenberg that he better apologize or I'm going to ask for sanctions. Here's what he says. After the hearing, I, Tuxbury, initially initiated a meet and confer on this issue with Reed's counsel, Attorney Seligson, explaining to Reed's counsel that the misrepresentation was serious, clearly contradictory to the record, and sparked substantial public attacks on Colin. But wasn't he already at boot camp? He wouldn't have even seen them. You're telling us he went to boot camp on June 3rd, which was the same day as the conference. He doesn't have access to his phone or social media. So how would he even know about these public attacks? Are you telling him about it? So crazy. Yeah, you know what's so great about social media? You don't have to look at it. You can actually ignore it. Thank you. Microdots is here. Thank you for your 10. Never heard such fiction. No, never heard such fiction. Everybody's a crybaby. Everyone wants their privacy. The following day, counsel for Colin Albert reached out for an explanation and a willingness to see if Attorney Rosenberg was willing to retract or clarify his statements. Yes, I want you to be publicly spanked. You better retract it or I'm going to come for you. You better not let Turtle Boy on your show, Tim Cast, or we're going to come for you. This guy's full of threats. He's the guy who wrote the letter to Tim Pool, right? Saying, you know, if you have Turtle Boy on your channel, he's just going to come on and defame my clients more, and we're going to come for you because under our fantasy, anybody who allows someone on their YouTube channel who defames someone else can also be sued for defamation in our fantasy. Okay. Now he's the internet police too. Attorney Rosenberg said that he would evaluate the wording and let counsel know whether they needed clarification. Then he filed on June 5th, he filed unilaterally with the court a letter that did not correct the record, but rather continued to make misrepresentations. Oh, I'm sorry. So his public apology in the court record was not good enough for you, sir? This guy, I don't know what this guy's game is or what his like area of practice is, or if this is what he does, or if he, I just don't know, but this is not how like real lawyers behave. It's just not. I've never seen anything like this. I mean, Cosgrove is like a Boy Scout compared to this. Argument. And then they go on to say that they didn't cite any cases and there's fabricated claims, and all they're doing is using this as a mechanism to continue to harass Colin and impugn his character. More defamation, more defamation. Everybody's harassing Colin. Oops. And impugning his character. Everybody's brainwashed. Turtle Boy bad. Rosenberg also bad. Right. Carlita is here for the mic drop, says, I don't understand why you file a lawsuit, then leave for the military. Like that's going to get you out of something. Or like if you file a lawsuit and you're a plaintiff, you have to prosecute that lawsuit. You have to be available. It doesn't make sense. You're right. And then on and on and on with the back and forth and back and forth and back and forth. And no. Colin appeared for his deposition. They didn't show up. They refused. He goes on for pages about this. The subpoena is overly broad. He shouldn't have to provide any of this stuff. He looked. He couldn't find anything. He only has that one text. That's all he has. He shouldn't have to appear anyway because he's not really relevant here. Here it says, the motion itself acknowledges Colin's testimony that he left 34 Fairview prior to the arrival of Reed and O'Keefe. Colin has testified to that fact under oath on 3 separate occasions, including in his deposition in this case, which Reed's team did not attend. Okay, so 1, I guess, was the trial number 1. I guess 2 would be the federal grand jury because he did not testify in the state grand jury. Nobody even knew he was at the house that night when the state grand jury was convened. Federal grand jury, his trial testimony, and his deposition. And now he submitted an affidavit that nobody can read because, it's scanned improperly. Reed's baseless accusations that Colin has violent tendencies and that Colin and Mr. O'Keefe had a series of prior disputes are entirely unfounded, illustrated by the motion's failure to cite any evidence in their support. Well, they don't have to tell you all of their evidence. Colin Albert testified at trial number 1, the only one he testified at, and we looked at this recently, that he absolutely intended to intimidate the Advantage Boys when he said, "Pull up, bitch, bang, bang." That he was challenging them to a fight. Alan Jackson got him to say that. So, did you not see that part of the episode? Indeed, had Reed's counsel attended Colin's deposition in this matter, they would have learned that Colin and Mr. O'Keefe barely had any relationship at all, and that Colin certainly never harbored any animus towards Mr. O'Keefe. Donna, thank you. Donna, are you talking about the DA debate that's happening last night for Norfolk County DA? The event will not be live streamed, but is being filmed by Medway Cable Access and will be posted for an on-demand viewing after it's processed. Okay, cool. Thank you for letting us know. Then they go on to talk about the scabs on the knuckles and all that stuff. First of all, what is he doing in a bar? Getting his picture posted on the bar website, the bar Facebook, because that picture of him with the busted up knuckles came from I don't remember the name of the bar, but it was on Facebook. It was a Facebook posting that the bar posted. So they're posting having underage kids in their bar. So many things wrong with this. I can't even pick one. Again, these photographs had no metadata, and I looked at the sidebars, and Yannetti also objected to those photographs coming in, but the judge was like, "I'm going to let him in with the unharmed knuckles." Notably, the document subpoena does not seek photographs of Colin following the death of Officer O'Keefe because Reed knows that such photo would undermine her fantasy. Oh, she's fantasizing again regarding Colin's involvement in Officer O'Keefe's death. For some reason, I just don't think Karen Reed would be fantasizing about Colin Albert, but you go on with your bad self, Tuxbury. On its face, the subpoena treats Colin as though he were a party to the case, or worse, as though he were a target of an investigation, and demands a comprehensive accounting of his entire private life. Well, here's the thing. Again, do I have to point this out again? You filed a lawsuit on his behalf as a plaintiff. And so, yes, he is going to have to account for his whereabouts and his communications from the date of the death of John O'Keefe for at least a couple of months afterwards. Okay? Because he's a plaintiff too. We don't know who's the target of what investigation, because if you think the FBI has pulled out and is not still investigating this, I think you're probably wrong. Listen to this argument. These assertions lack any basis in fact. Indeed, during her second criminal trial, in which significant latitude is afforded to a criminal defendant, Reed was expressly barred by the court from arguing a third-party culprit theory with respect to Colin. Yes, right. Based on perhaps an erroneous ruling by Judge Cannoni. Doesn't mean that they can't argue it in civil court. In any event, the motion provides no basis upon which Reed would be entitled to such extraordinary and invasive tranche of discovery against a third party, a whole tranche of it. as a covert means of obtaining irrelevant discovery from a non-party solely to impugn that non-party's character and reputation? No, no. In fact, you as his attorney should be voluntarily giving all this shit up so that you can prove that Colin Albert was nowhere near 34 Fairview when John O'Keefe was murdered. That would help you. That would actually help you. But you don't want to do that. You think all of this is being done to impugn your... How about you pugn it? Okay? I don't even know if impugn is a word. They want to impugn your client. How about you pugn your client by giving this stuff up and saying he was nowhere near 34 Fairview when this happened? Pugn, 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 pugn. Somebody said it was called what? Fenway Joe's or something? Pugn, pugn. Oh, that was good too. Karen's still wearing pink. It says ATOS. Fenway Joe's says Venus Blue Cupcake. That's what bar it was at. Moreover, Reed's own proposed narrowing demonstrates the overbreadth of the other blah, 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 blah. Oh, and then they get to this. It's too burdensome, but then Section C. The court should deny the motion for the independent reason that Reed's counsel violated Massachusetts Rule of Professional Conduct 3.3a. Oh boy. Oh boy, let me tell you something. Once you start accusing other attorneys of ethical violations in your papers and citing the rules of professional conduct, gloves are off. Gloves are off. That's a disgusting thing to do. And remember, this motion, well, don't remember because I didn't tell you yet. Okay, this was served on counsel June 9th by Tuxbury. That hearing that they were talking about was June 3rd. What kind of attorney starts or accuses another attorney of ethical violations in open court like this? You don't. It's not a cool thing to do. And here's what he says. For years, Colin and others have been subject to outrageous abuse for no reason other than his willingness to cooperate in a law enforcement investigation into the death of Officer John O'Keefe. Listen to me. He was not willing. They didn't even look for him. They didn't even look for him until what? 18 months after the murder of John O'Keefe? Nobody even questioned him. His name was never brought up. Proctor wrote down his name in his notes and forgot to put it in the reports. He was hidden. Okay? So don't come in here on your high horse saying that he was willing to cooperate. Nobody ever asked it. Right? What investigation? What investigation? Yeah, Billy Bush made it too. Billy Bush is in here too. Listen. That abuse has included defamation and misinformation that has been publicized by Reeds and her attorneys in a judicial forum. Indeed, the rule of conduct 3.3a1, this is the ethics rules for lawyers, provides that a lawyer shall not knowingly make a false statement of fact or law to a tribunal. Oh, kind of like when Diller said that Karen Reed said on that illegally recorded phone call that somebody illegally published. I'm dead. I'm effing dead. You mean like that? Like Diller making a false statement to a tribunal when she said again, effing again? Kind of like that? The guy, that you're behind the scenes with trying to coordinate your client's deposition with less than 7 days notice? Okay, cool. I see how this is going to go. This is dirty. This is dirty pool, and I don't like it. This duty of candor is among the most fundamental obligations an attorney owes to the court and to the administration of justice. Okay, like you saying that Colin Albert was unavailable because of a work issue when he really got... Oh, unless you're representing your clients and then their privacy is paramount, so you're allowed to lie? Is that how it goes? See what I mean when I say you can't use that as a shield and a sword? The rule recognizes that the integrity of judicial proceedings depends on the truthfulness of representations made by counsel, and that courts are entitled to rely upon those representations on making decisions that affect the rights of oh yeah, really? Like again, effing again? Anybody remember that? Did I dream that? Was it part of my fantasy? Courts possess inherent authority to impose sanctions for conduct that abuses the judicial process. This is so gross. Asking for sanctions for something like this is gross. When someone shows you who they are, believe them the first time. I mean, this is going to affect his reputation, Tewksbury's reputation as an attorney, among other attorneys in Massachusetts. Nobody's going to want to deal with this guy. Who's going to want a case against this guy if he's going to start asking the court for sanctions and call and because sometimes in some states, I don't know about Massachusetts, but if someone accuses you of like an ethical violation in papers like this, sometimes the judge is duty bound to then forward this to the Bar Association for them to investigate you. That's why it is so not cool. Further, misrepresentations by counsel in a case such as this will have a profound effect on various non-party witnesses, including Colin, because they are immediately relied upon and used by online purveyors of lies who have adopted Reed's baseless claims and used them to torment and harass those witnesses. Every single one of you has been brainwashed, and you're all purveyors of lies. And all of Karen Reed's claims are baseless. I mean, Michael Morrissey, the district attorney, said it too in his hostage video. So, you know, it must be true. It is for this reason that the court should treat such misstatements, especially those that are endlessly parroted against the various non-party witnesses, very seriously. Oh, so what you're trying to do then is, again, stifle free speech, make sure that the First Amendment dies in Massachusetts because people should not be allowed to talk on the internet. Okay, so you're going to start what? Sanctioning everybody and suing everyone? How many more people are you going to add to your defamation lawsuit, Mr. Tewksbury? Karen Reed was found, in case we need to remind you, Karen Reed was found not guilty. She was acquitted in a court of law. And Lil the good dog says, why are they allowed to continue to pretend that didn't happen? As detailed below, counsel's collegial efforts to convey this concern to Reed's counsel was met by indignation, followed by the submission of a convoluted and misleading letter to the court that only compounded the harm. Well, you started it. Mommy, he's breathing my air. Mommy, she's looking out my window. Mommy, he's touching me. Make him stop touching me. Mommy. Catherine's like, yeah, Catherine says, right. Not the best marketing strategy for an attorney. Yeah, their fundraiser this week is on Juneteenth, which is really ironic after Michael Proctor's virulently racist messages came out. Juneteenth. No decaf for me. No, that's what it is. No decaf for me. Their fundraiser this week better be successful. Sounds like their lawyer's worried about cash money. Coconut Cupcake says, these people think we're stupid. They're telling us everything. Lola said, thanks for your 5. You're not dealing with Judge Beverly C anymore. This judge ain't playing, Colin. Lola, thanks for another 5. Can Karen Reed's lawyers travel to basic training and depose him there? No, but there are some rules that say that he could have to come back for a civil deposition. I think in those are like JAG rules or something. I don't know. This feels planned / shady. I would love for Karen Reed's team to surprise Colin with a visit. Thanks for your 5. Stacey, I love you with all of my heart too. I love you with all of my heart. Kurt Smith, question. How are the McCabe and Albert attorneys getting paid? Is it only if they win? Is it customary to do this much work, hoping to win? Well, this is what I'm saying. This is outside the scope of their civil defamation case. And so typically a plaintiff's case would be taken on contingency, but only for that case. And then they don't get paid unless they win. But they've already raised something like, somebody said, $250,000 in their fundraiser because they're billboard and stuff. And so I don't know if that money is going to pay these lawyers, but this 107-page opposition for a motion to compel Colin Albert to appear for deposition costs a lot of money, in my opinion. I think they had to pay for this, but I'm not entirely sure. I don't know the scope or terms of their retainer. And Donnie says, is military required by law to obey a subpoena? I don't want to give you the wrong answer, so I'm not going to give you the wrong answer because I haven't researched it. Thanks for your deuce. Ellen says, what standing do the bars have on joint discovery when they're not parties to any other lawsuits? They could agree to it just for purposes of a consolidation. And they might. They're getting paid by insurance companies. And so the bars aren't paying for their attorneys. Karen Reed, in this case, O'Keefe versus Reed, her car insurance company is representing her. She might also have an umbrella that might kick in. And so they could agree. And they did agree, according to the hearing that we just watched. Thanks for tuning in from Denmark, Ellen. Okie dokie says, I like this judge. Thanks for streaming. You're very welcome. Minnesota Mama, if any of the O'Keefe's or Haas defendants' lawyers come across information that implicated them in the murder, do they have to report it? No, I don't believe so. Anything that they would discover in the course of their representation would be attorney-client privilege. And that was a good question. Thank you, Minnesota Mama, for your 5. Ellen says, thanks so much for finding the stream and helping us through it. Thank you. A lot of volume issues, but what are you going to do? Can't please everybody. Kai says, nothing like making it obvious that you're all of a sudden concerned about your kid's involvement by showing up to a case you're not a party to. Jenny 3 times. Thanks, Kai. Minnesota Mama, the P.S. The Real Housewives of Rhode Island ladies all said Block Island is beautiful this time of year and went on a trip there. That's hilarious. I thought of you and giggled. That's so funny. A couple of you told me that. I haven't been watching that show, but should I? Should I? All right, let's keep going. And then they're going on and saying why they should also be sanctioned. Here, the misrepresentation by Reed's counsel to the court during the June 3rd status conference undoubtedly violated Rule 3.3. First, the statement was false. Colin did not refuse to appear for his deposition. The email correspondence attached here too confirms that the Reed team canceled the deposition and never rescheduled it. Second, the falsity was known to Reed's counsel at the time he made the statements. Colin did not refuse to appear for Reed's deposition. Reed counsel canceled the deposition just 6 days after the subpoena was served on Colin. Again, now we're just, it's semantics, okay? They didn't cancel it. They said they were going to reschedule it. The court today did not even address sanctions at all. And so I don't think he's going to. He said, come back Monday and give me dates for Colin's deposition because this isn't going until the fall. He said, that's not happening. We tried to confer. Instead, they're personally criticizing me and said that we were playing games. I don't like that. Although Reed's counsel ultimately agreed that his statement that Colin refused to appear for a deposition was somewhat inartful in context and stated his willingness to clarify the record with the court. He failed to do so. Please, Judge, please spank him. Please spank him for me. And then he unilaterally submitted an ex parte letter that provided the court with a narrative of his position regarding the April 21 subpoena. I know you are, but what am I? This did not remedy the harm, but compounded it. This is so childish. I'm going to scroll through it in case you want to read it, but it makes my head hurt because it's stupid. It's like, look over here, look over here. Don't focus on the fact that Colin Albert, out of the blue, all of a sudden enlisted in the military. Because we did produce him, because Diller said he would do it in a 6-day window, specifically one of the 2 days that Chaz Waters was out of town. And by spewing on and on and on about this for pages, not only are you charging your client a hell of a lot of money, but it looks stupid. It looks like silly name call. Is it me? Am I being hyperbolic? It's so childish. Is this real life? Oh, here we go. The harm flowing from the misrepresentation has been substantial. Colin has been subjected to a campaign of online harassment and intimidation that was sparked directly by Reed's counsel's false statements in open court. Okay, I guess they're going to sue him now too. Indeed, in the hours and days that followed the June 3rd status conference, disturbing comments were publicly made in direct response to Attorney Rosenberg's misrepresentations, including, among other things, that Colin made the decision to serve his country in order to flee his deposition in this case, and that such decision meant Colin, quote, can kill legally. Other comments made immediately following the status conference included that Colin was complicit in murder and accused Colin of dodging a deposition with Olympic-level agility. See Exhibit 9. Okay, didn't they say that Colin went away to boot camp on June 3rd, so he wouldn't have seen any of this, right? But no, let's go to Exhibit 9, because these are their examples of all of the harm that people posted online. Some of you might be in this chat. Exhibit 9. Number 9. Number 9. Number 9. Oh, we're only at 7. Nine. Here it is. Here it is. Here's what people posted on the internet. Uh-oh. Boozy Beauty, you're in trouble. Actually, you're not in trouble. It's somebody's response, I think, to yours. Okay. Boozy Beauty on June 3rd tweeted, according to today's O'Keefe versus Reed Canton Bar's hearing, Karen Reed's attorneys are preparing motions to compel against several witnesses, but the situation involving Colin Albert stood out. Reed's attorney, Aaron Rosenberg, told the court that Brian Albert, Nicole Albert, and then they didn't expand the tweet to tell us what else Boozy Beauty said. But there's a picture that says Colin Albert dodging depositions and discovery. But what stood out to them as being damaging to Colin Albert is somebody whose name is, I can't read that, ISRIS maybe, responded to this tweet and said, oh, good, Colin is going to learn how to murder more efficiently. That's one example. The next example comes in response to an Aidan Carney tweet of June 3rd that says, Colin Albert has suddenly decided to join the Army and will be unavailable to give a deposition in the Karen Reed lawsuit. Okay, there's nothing false about that statement. Hopefully, our country is a little safer now that we are being defended by a person who testified that an award-winning journalist speaking into a window. They didn't expand on that, but I think it probably goes on to say something like, he's afraid of me speaking into a window with T-Rex arms. And then there's some pictures of the publicly posted swearing in ceremony. Uh-oh. And then Susan said, does the Army know that he was in the house? I mean, Susan, how dare you? We have a how dare you emoji. Please use it. Susan tweeted this on June 3rd, 2026 at 6:07 p.m. Does the Army know that he was in the house? And here's some more examples. Sir Earl of the Grey tweeted, dodging your disposition to get sent to war. Good option, Colin. That doesn't make you and your family look ridiculously guilty. P.S. Everyone knows your murder is based on your own testimonies. Dr. Turtleboy has nothing to do with that. Sue me. That was Earl Grey retweeting Boozy Beauty. You can't make this up. You just can't make it up. And then someone named Kat Ryan tweeted, now Colin Albert can kill legally. This is the Afro Man effect. Why are you doing this to your client? Big Daddy D. So Kat Ryan, it looks like, retweeted Big Daddy D on June 3rd. Big Daddy D said, guess who is fleeing in order to not be deposed and answer the tough questions? Just because you join the service, it won't shield you from prison. Bang, bang. I mean, and literally it only, okay, here's the funniest part. As of June 3rd of 2026, whenever somebody screenshot this, it only had 728 views. It only had 728 views. How many views do you think it has now?
You're welcome.
You, sir, I would submit, are causing more damage to your client than had you just left this the flip alone. The one before this, Sir Earl of the Grey, that had 1,068 views. Does the army know that he was in the house? Had only 3,240 views with 138 likes. And somebody's like, I'm so glad they're reading our posts. Oh, good. Colin's going to learn how to murder more efficiently. That only had 903 views. What is it that you say you do here? Maybe Colin can sue you. Like Saul Rosenberg. I'm going to sue everybody. I'm going to sue you. Remember the Jerky Boys? But wait, there's more. Boston Brandy tweeted, Colin quickly enlisted. Will they get him before he jets off? It's amazing how some people can dodge a deposition with Olympic-level agility, then suddenly discover a calling to serve when sworn testimony's on the horizon. Uh-oh, Boston Beauty. Are they going to come for you too? Boston Beauty. Boston Brandy is different than Boozy Beauty. This is different. And there's a TikTok attached to it. That one had 14.2 thousand views. June 3rd, 2026. I wonder how many it has now. Oh, wait. There's more. Susie said, ooh, Colin refusing to appear. Why, Colin? Then saying you're only available for 7 days and that's it. What's up, Colin? Bang, bang. Refused to produce documents. There's a picture of the Zoom hearing or the Zoom screen. That had 3,990 views. And there's another Boozy Beauty tweet. Same tweet as before. Sir Thomas A. Wade, you've made it, sir. Commented on Boozy Beauty. Nothing fishy about that timing at all. The McAlberts are hands down the dumbest yet most transparent criminals of all. First, they try to hide little Collie Bear and now force him to enlist and ship off to boot camp. Can't help but feel a little sorry for this now man child. That one had 2,313 views. But, you know, the Afro Man effect is real. It's real. And I wonder how many views it might get now. Again, better want what you wish for. I mean, is it me? It might be. Well, they're talking about the tweets again, the mean tweets. Mean tweets for a whole page. Oh, now they're going to bring Billy Bush into it. Oh, they're bringing Billy Bush into it. Even after Colin's counsel put Reed on notice of her counsel's Rule 3.3A violation. Oh, well, it's not really nice to accuse an attorney of an ethical violation. But even after I accused them of an ethical violation, Reed's counsel nevertheless continued to project the false narrative that Colin refused to appear for a deposition. For example, on June 5th, during Reed's recent media campaign, her recent media campaign, right? Attorney Alan Jackson appeared on podcaster Billy Bush's YouTube show, wherein he discussed the issues pertaining to Colin's deposition. Oh, we know because we watched it. It was great. On that show, Attorney Jackson stated that Colin, quote, has not been deposed yet, accused the undersigned of engaging in shenanigans and playing a few games, and alluded that the Reed team intended to reissue a deposition subpoena on Colin, notwithstanding his recent enlistment in the U.S. Army. See Hot Mics with Billy Bush, Karen Reed, Today Show interview reacts and bombshell lawsuit exposing gross texts and Massachusetts institutional bias. The YouTube video from June 5th, 2026. Up. There's Billy. There it is. Hold on. Oops. Well, it's got 61,000 views. It was streamed 12 days ago. Let's see how many. We'll bookmark that for later. 61,000 views. How many more views is it going to get since they put this right in the body of their opposition to the motion to compel Colin Albert to appear for a deposition? For any of the foregoing reasons, the court should exercise its inherent authority and deny the instant motion because of Reed's counsel's ethical rules violations. Here you go. Here's what they want. And the judge was like, yeah, no, that's not happening. Had Reed's counsel engaged in good faith to reach a reasonable consensus regarding the subpoena, this motion practice would have been unnecessary. They refused to do so. Instead, they offered Colin hollow compromises, which were indeed not compromises at all. Refused to coordinate their schedules to accommodate his recent and commendable career change. Well, thank you for your service, Colin Albert. We commend you. We commend you, Colin Albert. And subsequently made entirely false misrepresentations in open court. Contrary to Reed's accusations, the only one engaged in gamesmanship here appears to be her. For the foregoing reasons, the motion should be denied in its entirety and the court should grant any further relief deemed just and proper. Meaning what? The motion should be denied, meaning he shouldn't have to appear for another deposition? Good luck with that, sir. XOXO. Colin Albert by his attorney, Jimbo Tuxbury, Boston, Mass. 02134. Send it to Zoom. I mean, okay. Here's the affidavit of Kieran Murphy saying, yeah, I did all this and that and the other. That was exhibit 1. And then this exhibit 2, this exhibit 1. No, that was just an attachment. This exhibit 1 this is supposed to be Colin Albert's affidavit. You see what's happening here? It's only half a page. We can only read 3 words on each line. Paragraph 2, 3, 4, 5, 6. They didn't ask for this to be impounded. Somebody just what? Scanned it in wrong. And then it just jumps from paragraph 6 to paragraph 16 and 17. And there's, again, only 4 words readable on each line and then a scribbly signature that purports to be page 2. So that's that. That was a good, I'm glad we got a live stream of that hearing. I thought what I'd like to do with you after this, if you like, is watch the entire Foreman juror interview that has been recently released that took place at Fisher College. If you'd like to do that, I had a couple of options of different things to do. Sunshine Love said, I'm upset my tweets didn't make the cut. Who do I sue? It's a half-a-davit. I love sarcasm. It's a huff-a-davit. It's a huff-a-davit. Magurd. Lauren says, my Life 360 notifies me when my daughter arrives home and I look out and see she's pulling in the driveway. Cauliflower says they can go to the military base and do the deposition. Thanks for your super chats. Cupcakes for Justice says at this point, Colin in the Army, Proctor in the hospital. Who's next to disappear? I honestly don't know where Proctor is. I have no idea. Thank you for your 5. Oh my God, you guys keep me laughing. It's literally half a David. Shannon again 06 says motion to change his name to Suxbury. Suxbury. Hold on. Let me get to the prop bucket. Motion to change Duxbury's name to Sucksbury. Motion granted. Thank you, Shannonigans. You just can't make it up. Kristen DeMoro, thank you for your super sticker. Juan says, Colin wears different hats. Colin wears a different hat in the photos on the same night. Thank you for tuning in from South Africa. I love you so much. I couldn't, those photographs were so blurry that I couldn't even see that he was wearing a different hat. But that's a great point. If we ever get there and we get good copies of those photographs, we'll know. Boss baby emojis in the chat. Thank you, Cupcakes for Justice, for gifting 5 memberships. And Brass says, it reads like Tuxbury decided to add to his defamation filings via this. He seems to spend more time there than on why Colin should be able to delay. Right. He's trying to bolster his defamation case by all of the things that he wrote. Of course, you can see it, right? Of course you can see it. Allison, thanks for your 10, says Tux came prepared to set everyone straight. Haas defendant perplexed why their adult child isn't on a protected / going to summer camp. Jen and company look ready to take the helm with the impoundment win. Yeah, all of their communications with Proctor and anybody related to Norfolk DA's office are impounded for now. Thanks, Allison, for your 10. Thank you, Suzanne, who says, your memo, she says, Colin is in Army preschool. I can't stop laughing. Well, now I'm not going to be able to stop laughing. I mean, sometimes we got to laugh or we're just going to cry, but sometimes laughing is justified. Venus Blue Cupcake says, if Trek's arms and journalists scare Colin, his first knife, hand, and shark attack is going to shock his conscience. I'd love to see his ASVAB scores. Love you with all my heart. And Piccolo coming in hot with a 5 says, Colin is the Chris Melton of this case. Love you, Mel. I mean, it's crazy. Hello, Karen. Thank you for your message. I'll take a look at that when I can. Tennessee Jed. Strongleg 1971 says, if the U.S. Army JAG knew that Colin had an outstanding legal subpoena conflicting with his entry to boot camp, JAG would make sure he met his responsibilities. Just saying. Stand with Mel said, Allie and Bob read the summary section of Rosemary's motion to dismiss. Did you see that? It has allegations about Lally's violations. I was going to send it to you, but I don't know your email address. I told you earlier that my email address, but I thought I read the whole entire motion to dismiss. I read the second motion to dismiss. Could it have been in the first motion to dismiss? Because I was trying to figure out where that was coming from. Thank you. I'm kind of tired of reading tonight. I wanted to play a video. You know, it's like movie day and when you're in elementary school and they show a movie instead. You get to watch the movie for a little while. Sometimes my voice needs a break. Thank you, Uncivil, for being here and for your super sticker. Hi. Drop. Microdots is here and said, I never heard such fiction. It's fan fiction. It's fan fiction, Microdots. Can't wait for your next drop. Fan fiction. Thank you for your 10. Sandy said, if Colin were my son and he was innocent, I'd turn over 4 years of communications and everything else I could to prove it. What are they hiding? I mean, I think mothers would do that, right? But then with the mother here, the mother in this instance, Julie Albert, mother of Colin Albert, I mean, it came out during trial number 1 that she sent a text message to Courtney Proctor, Michael Proctor's sister, saying, tell your brother I want to get him a gift when all this is over. And what's really sus about that is that the timing of that message was interesting, because I think it was the same day that Karen Reed was arraigned. She said, I want to get your brother a thank you gift when this is all over. What does she want to thank him for? I stand with Mel says, I just sent them. They streamed it. He sent the whole motion, all the shortcuts. He's been taken. No, I want to see all that stuff about Lally, and I want to you do it in a whole separate show, because it's wild, and Lally might be a lot deeper in this than anybody thought. Thank you again for another 10. Joey 3 Sticks is here and says, love you, Mel. Sorry, just joining. When will the hearing be on Colin's document production and testimony? Well, it was today. It was today. You missed it. Rewind. We got a live stream of it, and Judge Gildea is not happy. He didn't hear anything about the sanctions unless I was sleeping during that portion. But he did say, when Tuxbury tried to say, well, he's in boot camp, he can't give a deposition until the fall, Judge Gildea said, not going to happen. Not going to happen. By the way, today's Wednesday. You're going to come back here on Monday for another conference that I think is going to be in person again. So CBS Boston, please do the Lord's work and go there and broadcast it again for us, please. And you're going to come back here on Monday, and you're going to give me some dates that Mr. Colin Albert can be back here for a deposition, because they said, we can only talk to him. We can only talk to him for 1 hour a day. I mean, 1 hour a week, because he has no access to phones or socials. And if that is true, then he wouldn't have seen any of these horrible things that people said about him on Twitter, right? So he can't be harassed. If a tree falls in the forest and no one hears it, does it make a sound? I'm asking for a friend. Thank you, Joey. I love you too. So much. Thanks for your 20. Tony says, thanks so much for this, Melanie. I sprained my ankle a week ago and going stir crazy, but your read and all the chats are making me smile. Tuxbury's wild. Well, people want to call him Suxbury now, which I'm not going to allow. Oh, DEFCON 5, level DEFCON 5, Baby Shark. Baby, everyone all together. Baby Shark, do 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 do. Baby Shark, do 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 do. On the hot seat. Thanks, Tony. EKG says, leave it up to bottom-feeding shady cops and their shady family to hide shady bottom-feeding lawyers. They're why cops and lawyers have bad reputations. Yeah, that's a Taylor Swift song in there somewhere. Bad reputation. Lola says, me thinks his attorney doth protest too much. Thank you, Lola, the good dog. Carrie Berry, thank you for your 5. Sam with Mel says, my husband was in the Air Force and got a subpoena and he had to appear. AJ told Billy Bush a subpoena trumps the military and it doesn't excuse him unless AJ is mistaken. That was a good interview with Billy Bush. We played it. We watched it together. Music to My Soul says, the judge may not like how Diller interfered with a defense subpoena since he said something like, how would you know that? When he chimed in before. That's right. That's right. How would you know that? Seize the Day says, thanks for always bringing the cock out of light. Sunshine is the best disinfectant. No, right? Private Colin Pile, cheers. Hi on top. Thanks for your 5. Stand with Mel. Thanks for another 5. Says, those were chats from earlier. I understanding wanting to show a video. I remember when the teachers showed a movie, they took a nap. I know. The poor guys in boot camp with Colin are going to think they are on army duty. Oh, right. Like the jury duty show, but army duty. Like it's like a candid camera show. McGurd. Hold on, because there was something else that I wanted to show you. For those of you who missed it, let's just take a brief break from the Karen Reed saga to take a look at what happened today in Suffolk County, New York, Supreme Court. We call it Supreme Court here. With the Long Island serial killer and how the judge yelled at him. If you haven't seen it, this is just a short clip. It's only 4 minutes long. Rex Heuermann, the Long Island serial killer, was sentenced today. He will not see the light of day outside of a prison for a long time. Let's watch Rex. There was a camera in the courtroom today, which is very unusual in New York. It never happens. It just never happens. And there was today. And Rex Heuermann did say he had something to say after many victim impact statements were read by families of the 8 women that Rex Heuermann has pleaded guilty to killing. First one, I believe, was in 1993. All right, the judge. Okay, good. We're going to watch it again if you've seen it. This is only a 4-minute clip from Court TV. And this was just this morning. There's Rex Heuermann with his lawyer, Michael Brown. I'm kind of upset that we didn't get to see Michael Brown try this case because I really wanted to see him in action. And Rex Heuermann is going to have something to say, and then the judge is going to have something to say back to him. This happened just this morning. Come to your screen if you can. I remember the one time that I went to court on this case. It was in the very early stages after he was arrested. I'm sorry, what? Are you behind, Patty Felker? Can I turn my volume back up? My volume has been on auto since after. I don't know, maybe you're behind. You guys can hear me, right? It's so funny when people are like 2 hours behind in the video and they're commenting about things that are happening 2 hours ago. Now I lost my train of thought. Okay, the one day that I went to court in Suffolk County to see Rex Heuermann. It's a big courtroom. It's a very big courtroom, lots of pews. There was not a lot of people there that day. In most courtrooms in New York, I have an attorney's pass, so I don't have to go through like security and all that stuff. You just wave your pass and you go in. And in most courtrooms in New York, the first two pews, because they are like church pews, are for attorneys only. But here, the first two pews were for media only. So because I have an attorney's pass and not a media pass, I was in the third row. And at one point, Rex Heuermann turned around and I felt like he was looking straight at me. He was looking straight at me. And I am telling you that I got a chill like I have never had a chill in my life. This man is evil. He emanates evil. You can just feel the evil emanating out of him. Here's what happened this morning when the judge asked if he had anything to say after listening to all of these victim impact statements. Here we go.
To say before I pronounce sentence?
Wait.
Is there anything you wish to say before I pronounce sentence?
I don't know why that just buffered, like hella buffered. Hang on a second. Let's see if we can get this to play right.
Is there anything you wish to say before I pronounce sentence?
That's court TV, and that's not me.
Mr. Heuermann, is there anything you wish to say before I pronounce sentence?
Yes. There are no
Stand up.
Stand up. Stand up.
There are no words I can say. I am responsible for what was said in this room today. The words I would say have no meaning. And I'm going to leave it there at this time.
Speak up. Mr. Heuermann, as Mr. Tierney said, I know that you're sorry that you got caught. I assume that you're sorry for what you've done to your wife and children. Are you a little bit sorry for what you did to these poor innocent women? 8 women that you strangled to death, at least 8 that we know of. Are you at least a little bit sorry for that? Yes?
Yes, I am.
His name is Judge Mazzei, Mazzei. That's how you pronounce it, Mazzei. I think his first name is Timothy Mazzei. And he is pissed.
You know what? You've been described as a very big man, but you're a disgusting and despicable small man, if you're a man at all. And you're a coward. As a result of your plea of guilty to murder in the first degree and count 1 of indictment 73544 of 2024, it's essentially court that you serve the rest of your life without the possibility of parole. With respect to count 2, murder in the first degree, it's essentially court that you serve the rest of your life without the possibility of parole. With respect to count 3, plead guilty to murder in the first degree, it's essentially the court that you serve the rest of your life without the possibility of parole. Those 3 sentences to run consecutive with each other. With respect to count 7, murder in the second degree, it's a sentence of the court that you serve an indeterminate term of imprisonment with a minimum of 25 years and a maximum of your life. With respect to count 8, murder in the second degree, it's a sentence of the court that you serve an indeterminate term of imprisonment with a minimum of 25 years and a maximum of your life. With respect to count 9, murder in the second degree, it's essentially court that you serve an indeterminate term of imprisonment with a minimum of 25 years and a maximum of your life. And finally, with respect to count 10, murder in the second degree, It's the sentence the court to serve an indeterminate term of imprisonment with a minimum of 25 years and a maximum of your life, all of those sentences to run consecutive with each other. Mr. Tierney, with respect to counts 4, 5, and 6,
Move to dismiss, Your Honor, in satisfaction of that sentence.
that application granted. Other agencies to collect. Anything else, gentlemen?
Nothing from the people. Your
Mr.
Honor.
Brown?
Nothing further.
All right, get him out of here.
Get him out of here. I think Judge Mazzei might be my new favorite judge.
Order directing the surrender of firearms, rifles, and shotguns. That order will go back with you.
Sorry, I was speaking over it. Hold on. Get him out of here. He's like 6'4". I don't know how much he weighs, but he's enormous. He was described in 2010 as looking like an ogre. And boy, does he. It does again.
Nothing from the people. Your
Mr.
Honor.
Brown?
Nothing further.
All right, get him out of here.
Serving on defense, order directing the surrender of firearms, rifles, and shotguns. That order will go back with you at the jail.
Kill you.
Remind me how many guns they seized from his house. It was over like 300. It was a lot. He was apparently a firearms collector. What did that person just say? Something about hopefully nobody kills you. Wait, listen.
Serving on defense, order directing the surrender of firearms, rifles, and shotguns. That order will go back with you at the jail.
Kill you.
I hope they grape you in the ass and kill you, somebody said.
Yeah, you know what the case is gonna look like. At least we know where you are.
Asa was not in the courtroom. She didn't show up today. She said she wasn't going to show up because she didn't want to pull focus from the victims. I agree, Ms. Mojo Rising. He absolutely is a monster. Oh, and look at that. My video was suggested by that video. I love when that happens. Somebody said they love the whipped beef tallow, which I am using as a facial moisturizer. It's amazing. I've linked it to this stream if you want some. I think it's still on sale for $30. The greatest thing I ever used on my skin, ever. And so I've linked it to this stream. That was Long Island serial killer Rex Heuermann, who has pled guilty to murdering 8 women here on Long Island over the span of, I don't know, at least 20 years, beginning, I think, in 1994 was when Karen Vergata's legs washed up on the beach at Fire Island. And his first victim, according to him, and what he's pled guilty to, was Sandra Costia in 1993. Turtle Warmbug says the cheers brought tears to my eyes. I think that this deserves its whole separate stream. I was waiting all morning. I was up early and I was waiting for a live stream on this so I could do it live, but there was no live stream. It was taped and then it's been dropped since. And by the time it was dropped, I already had this stream planned. And so I couldn't do it today because, you know, it's very spontaneous over here. We do things spontaneously, as always. Something else. Oh, Allie McCabe was trending on Twitter the other day. And that was one thing. Susan is here. She says, I don't understand how the lawyer is so convinced by the rubbish, the Haas defendants and Colin and their circle spout, and then uses that rubbish to argue. Do you know what I'm trying to say? I do. Makes me so angry. I know. You're not the only one. Was that you that they quoted in this? That made the comment on Twitter? Because there was a Susan, and I thought she spelled it that way too, S-U-Z-A-N, but I could be wrong. Thanks for tuning in from Canada. Let's everyone hit the like button while we're here. How did I start this stream? I don't even remember. Oh, Maria, thank you so much for your Venmo. Says, I love you so much. I love you more. When did we start here? A little before 3:30, right? So we're almost at the 3-hour mark. Oh, I see. So he's in a 3-week program. Yeah, I don't know about that. I'm going to have to look into that a little bit more. I see you guys are really doing some karma. You're putting some karma merch in here for me. Also, if you're going to submit a Karma Knows Your Address merch design, a lot of you are sending it to me on like a screenshot of like a t-shirt, which is great. But if your design is chosen, you have to be able to send it to me in like a PNG form, because that's the only way that I can upload it to Spreadshop. Okay. Hold on a second. All right, I will look into the rest of that. Tomorrow is what? Tomorrow is Thursday. Let's see what tomorrow holds for us. Oh, tomorrow the US Open golf starts. So that's exciting. It's right out here on Long Island. It's right out here, Long Island. It's at Shinnecock this year, which is pretty cool. Pretty cool. Tomorrow is the 1-year anniversary of the Karen Reed verdict. It was 1 year ago. It was 1 year ago that she was acquitted. It's the 1-year anniversary. Should we have a party? Kate says, if you look at the screenshot evidence where it goes 12:10 a.m., there's no text above it with the new date. It's a fabricated screenshot. I've looked through my own iPhone text messages to look for that. Some has it, some doesn't. So I'm not a forensic expert. I don't know, but a lot of people have said that. So thank you, Kate W., for pointing that out. It is also the anniversary. It is my 3-year anniversary since I started this YouTube channel. How many of you have been here since the very, very, very beginning? Hold on a second, because now I got to look and see the exact date. I don't know. YouTube sent me like a little pop-up like, it is your third. It's your 3-year anniversary. I got to go to my channel and see when the first live stream was. Who was here for that? It was, let's see. The oldest live stream on my channel was from what's the date? Okay, they're lying to me. It was July 13th of 2023. July 13th, 2023. My first live stream ever was on Kevin Costner's divorce. How many of you were here for that? Wow, I think I've grown a lot as a streamer since then. I go back and I look at some of my old live streams and I cringe. My first live stream ever, July 13th, 2023. Has 16,000 views. That's not bad for a newbie. You remember? So it's coming up. So maybe we should have a 3-year anniversary party on July 13th. I got to put it in my calendar. That's so crazy. 3 years on YouTube. We're at 135,000 subscribers and we need more. We need more. Billy Bush has surpassed me. I don't know. He just started his channel like 10 minutes ago. Yeah, that was after Duty Ron. I was on with Duty Ron a long time before I ever had my own channel. And then I started my own channel. That was my first live stream, July 13th. It was Kevin Costner's divorce. Tomorrow is Karen Reed Day. It is. You're using the whipped beef tallow as well. I know it's not for cooking. The flavor that I like the most is orange vanilla. I love it. I love it. It's changed my skin. Look. That's it. That's all I have on. I was in the sun today. I was gardening. I was pruning. It's magic. It is literally like magic. And for $30, they don't pay me. I just link their product to my stream and you should check it out. Oh, a lot of you first saw me on Duty Ron. And Leona Cleese says, damn, I remember when you had like 10,000 subs. Yeah. Oh, all about the shade says I started watching during Classic and Sincere. Yes, Billy already had a huge following. He's a Bush. He's Billy Bush. I used to watch him on Extra and Access Hollywood. And then I can't believe that I'm friends with him now. Now he's like my friend. That's wild to me. And he's already a celebrity. And also he's a Bush. He's a Bush. You got the vanilla orange too, and you adore it. Amanda says, I don't like Kevin Costner. He's a good actor. That's it. Well, his ex-wife, his now ex-wife, who then after the divorce, first of all, she tried to grape him in that divorce. She married his best friend. I think they're married now. What the actual F? And Derek says, I just watched Duty Ron for the first time yesterday. Kim says, why is the attorney worrying about Colin's money and the expense? Auntie Denise is fundraising to cover all the legal expenses. And then they're going to have their big fundraiser on Juneteenth. I mean, crazy, right? Oh, Tiff sent me something also in the Aiden Carney taint team case. I got to find it. Hold on a second. Because I don't think I downloaded it. But there's been an order in the Aiden Carney taint team case. This has been going on for like how many years now? Yes, vanilla orange smells like a creamsicle. That's exactly what it smells like, Sherilyn. It smells like a creamsicle and it brings me back to the good humor truck. Yes. Yes, it does. I love it. I love it. All right. Tiff, you sent it to me, so I gotta look for it now. Hang, please. Hold, please. I think we'll do the juror thing on a different show because it's an hour long, and for me to go through it, it's going to be a couple of hours. Also tomorrow, I have in my calendar, and I don't know if this is still happening because I got to check the court docket, is Lindsay Clancy's final trial conference is supposed to be tomorrow at 10 a.m. unless that's been adjourned. And we're going to cover that live because we've been following Lindsay Clancy for a very, very, very long time. Aiden said he's filing a huge motion this week. Oh, that should be interesting. Hopefully there's going to be stuff in it from Proctor's phone extraction if they were able to get it. Hold on a second. Oh, thank you, Tiff. Okay. So it's an exhibit. That's why. Okay. Got you. Because I couldn't find the first motion to dismiss and Miles King. That's gonna need its own show. That Lally shenanigans are going to need its own show. Let me pull up the there it is. And this is hot off the press as of yesterday, and this is in the Commonwealth versus Aiden Carney. This is the case that is especially assigned to Judge Belizos. Let me pull this up. And I have not read it yet, so it'll be a cold read. Cold read. They do have all different kinds of scents. I think there are unscented as well. This is regarding Aiden's phone, and they were trying to remember they've been trying to get a taint team. Aiden still doesn't have his phones back, okay? His phones were seized in October of 2023, and he still does not have his phones back. Yes. Penny says, I'm loving the tallow. Also, I'm 65 and I've used expensive stuff. Tallow is amazing. Me too. I love it. I love it. It's better than La Mer. If you ask me, it's better than La Mer. I'm not Bethany Frankel. Nobody gives me free stuff, okay? Although if La Mer did want to give me some free stuff, I would totally take it. I would totally take it. I didn't even know whipped beef tallow was a thing that could be used for. It's also good for scars. It's also good for moisturizer. You can put it on any part of your body. It's good for dry skin. And I'm talking to Kelly Reed, and she's like, "Of course, I've been using it for years." And I'm like, "Girl, how do you not tell me your secrets? I always tell you how good your skin looks." I'm like, "What's your secret? And how do you not drop on me the beef tallow? How is it that I got to find it myself?" It has lipids in it, so it doesn't really put moisture back in your skin. And if you research whipped beef tallow, it'll tell you that most moisturizers are made out of water, and so they don't really absorb in your skin, but it's got lipids. I don't know. I'm not a skincare expert. It's not my face cream. It's not my face cream at all. I don't know if you're allergic to coconut. I have no idea. All I know is that it's linked to this stream. You can go research it on your own. I am not saying it works for everyone. I am not saying that it doesn't clog your pores. I'm not just if you have $30 to spare and it helps with eczema, I mean, it's amazing. And it has something to do with the lipids. I don't really know. I'm not an expert. And the last time an expert tried to come in here and peddle skincare products in my chat, they then, after I called them out, they then went over and like did a whole show on Melanie Little called me out. So that's ridiculous. Colorado. That is great because it is so dry in Colorado that every time I go there, my skin dries up like a prune. I know. New and better moisturizers. It's amazing. I really like the creamsicle one. All right, let's take a look at this. This is the Judge Belizos. This was filed yesterday. Commonwealth versus Aiden Carney. This is the Commonwealth's motion to authorize the clerk's office to transmit to counsel a copy of the special master's report to the court, currently impounded. Okay, this has been going on for years. Okay. If anybody wanted proof of life on Cosgrove, here it is because he filed something in court yesterday. So it's not an order. I was wrong. It's a motion. Now comes the Commonwealth and states and moves as follows. Upon inquiry, undersigned counsel was advised by an assistant clerk that the specially appointed forensic examiner, Stephen Verino, has filed a report with the court and that the court, Judge Doolin, ordered the report sealed. Okay, when was it filed? When was it filed? Like a year ago and you're just moving now? I don't know because he doesn't say. On information and belief, the report is not the final product of the taint team containing the contents of the search devices belonging to defendant Carney and identifying any attorney-client privilege material, but is in the nature of an interim report advising the court as to where the taint team is and when they reasonably expect to complete their task. What? They're still not done examining his phones? May I remind you that Brian Walsh, who has been convicted of chopping up and murdering his wife, Anna Walsh, his phones were seized by Procter and Co. and extracted and returned to him within 18 hours. Okay. And yet they just can't seem to finish the search on Aiden Carney's phones. This is outrageous. It's outrageous. Assuming the above to be correct, the Commonwealth moves that the undersigned special prosecutor and counsel for the defense be provided with a copy of the report. It is desirable for counsel to know where the taint team is in the process and to determine whether their report raises any issues that should be brought to this court's attention. This case is scheduled for trial in December, okay? How are they going to how much longer are they going to dick around for? Alternatively, if, contrary to the Commonwealth's belief, the report is the final product of the taint team, i.e. designation of privileged and unprivileged data pursuant to the taint team protocol established by this court, Judge Krupp, that report should be provided solely to defense counsel, but with notice of such provision to the Commonwealth so that the defendant may file any objections to the taint team designations in timely fashion pursuant to the protocol. Has Aiden even talked about this? Does he even know that this is out? Obviously, I can't watch everyone's show or basically anyone's show. So unless you guys send me clips, I don't see hardly anything that's going on. Wherefore, the Commonwealth moves that the within motion be allowed. XOXO. Bobby Cosgrove, surprise, Special Assistant District Attorney. And so there's that. So they've filed the forensic examiner, Stephen Verino, and I want to know why that examiner is very familiar. That name is familiar to me. Did they also appoint him or suggest him to be in the Karen Reed phone taint team? So it's like what? An interim report? It's not the final report of the taint team? They've got a lot of his devices, including like his kids' stuff, like his kids' iPads, I think, and stuff, maybe, or phones. And they have nothing on them. It says memory. These phones are old and have nothing on them, says Aiden. But yet they're just going to keep jerking and jerking and jerking around. So I guess Cosgrove's doing some work. He wants to get his monthly hours, his monthly billing hours in, and so he filed a motion. Yes, he's in on all the taint teams, says Sherilyn. That's true. That's true. They already have his current phone downloaded. Okay, so taint nothing happening. Taint nothing happening, says KPT. Taint nothing happening. No way, no how. Arg. All right, so here's the preliminary plan for tomorrow is that if the Lindsay Clancy hearing goes ahead, we need to see Kevin Reddington. I miss Kevin Reddington. I need to see more of him. Lindsay Clancy's final pretrial conference is supposed to be tomorrow at 10. I'm sure someone's going to be live streaming it because they always do. If not, I will get the Zoom link and we will Zoom in because that judge is okay with us doing it. And then I owe you a show because I really, really, really want to go over that juror interview with you because it's fascinating. Thank you, Kovia, for buying 5 matcha lattes. Oh, you're so sweet. I can't normally afford to support this way. Don't. If you can't afford it, don't do it. Don't do it. Your presence is my present. But you talking about paranormal activity and then conjuring being in the papers, I was monetarily inspired. Thanks for everything you do. Oh, thank you so much. Please don't ever. Tons of fun. 911 bought me 3 matcha lattes and says, we appreciate your coverage and humor. Thank you. Oh, I would not repeat anything that woman, that person ever says, and I wouldn't even. I don't even want her name mentioned on my channel. She's gross. That will be deleted, and so that's the plan for tomorrow. So just plan on that. Make sure you subscribe. Make sure you have your notifications set. Al Dente says they're trying to bury him. He's trying to avoid the drama. The people he thought were his friends are pulling a dirty deed versus helping him. Go figure. I don't know. I don't get involved in all that stuff. You know, I don't. That's why some of you love me. Some of you hate me for not getting involved. I don't have time for it. I'm too old. I'm too old. Okay. I have 3 daughters who have enough drama in my life. I don't need any more drama. C-Cow, thanks for becoming a member. Lettero Bebetero says you are the queen on the 2s of you. Oh, thank you for being over 29 months. Shelly, thank you. Because I was going to say this too. I'm behind on replay screaming at the TV. Take Colin's Mutta effing iCloud, period. Period. That's what's going to happen. If he looks through his stuff and he doesn't have anything, and then they have stuff on Proctor's phone that involves him that he says he didn't have, they have a good faith basis to make a motion for a Rule 17 subpoena to Apple or to get the iCloud or however they do that. I don't really know how it's done. I'm not a forensics expert, but it could be there, right? Listen, the Commonwealth was able to get it from extracting Michael Proctor's phone, and Michael Proctor's phone said that it had nothing on it. Michael Proctor said, his attorney said, we'll give it to you. You can extract it, but the only stuff you're going to get from it is within the last 30 days, because in February 2024, he got everything to auto-delete within every 30 days. And of course, that's not what happened. And look at all the fallout from that. Look at all the fallout from that. And if he was so innocent and everyone was also innocent with nothing to do with anything, wouldn't they provide it on their own to say, look, here's where I was. I wasn't there. It's not me. It wasn't me. It's the Shaggy defense. Mama She, thank you for your very generous 50. She says, so glad I found you. I'm so glad you found me too. I love you so much. I love you so much. It's wild. It's wild. And we know that they can get it because they got it for Proctor, even though he thought he deleted everything. Thanks, D. Nice Law, for being here for 3 months. Kathy loves polar bears, says, love Melanie and her mods. Cupcakes are the best. Thanks for being here for a year. Always pretty, always queen. Oh, thank you. On top, you're the greatest. And on that note, I will leave you guys until tomorrow. Thank you guys. Thank you, moderators, because I love you so much. I could never, ever, ever do this without you. And I think we should do a members only soon, but I want to give you guys enough notice so that you can consensually join or get gifted as memberships. Oh, you know what? Here's what I'm going to do. I can gift memberships. So let me give some memberships right now. Don't go anywhere because it's not up to me. It's up to YouTube. They decide who gets them. Let's do it. Ready? They let me gift 5 at a time. So here we go. On your marks, get set. 5 memberships coming out hot. And the 5 lucky winners are Shell 2837, Fresh Start Painting, Chrissy M17, Sue B 1019, and Cold Docket True Crime. Welcome, welcome, welcome. You were been gifted. Now go out and buy yourself a lottery ticket. Thank you, moderators. I love you so much. I could never do it without you. To everyone who chooses to spend so many hours a week with me, I love you more than you know. Stay cool, stay kind, stay classy. Stay safe. Don't believe everything you read on the internet. Love from Tejas. Wouldn't want to be anywhere else. I gifted 5 memberships. Yay, me. I will see you in the morning. Tentative start time will be probably before, if the Clancy hearing is at 10, we'll come in at 9:30. Make sure you have your notifications set. Do all the things that YouTube likes. You know what they are. You know what they are. I love you guys so. Oh, wait, let me see. There was one more thing that I did. I got to see if I can find it. Hold on one second. Because it's really funny. Like, I crack myself up. Hold on. Let's see. I did something funny, and I had a movie poster made of Bye Bye Birdie, but substituting Colin Albert in for Conrad Birdie. But I just don't know where I put it. I have to find it. So I guess I'm going to pull it up for you tomorrow, but because it's really funny, so I'll have to download it. So you have that to look forward to. Okay. Remember, we love you, Conrad. Yes, we do. We love you, Conrad. And will be true. I love Bye Bye Birdie. I will see you guys tomorrow. I love you so much. Peace out. Thank you, moderators. Tip your servers. I'll be here all week. Goodbye. Oh, wait. Card pull. Wait, first of all, did I read I have 2 quotes for you. The card of the day. The deck is I'll pull one. Okay, here's the quote of the day. Yesterday's quote. So you weren't here yesterday, is Immanuel Kant, who said, "The only thing permanent is change. Only thing permanent is change." There it is. And then today's quote of the day, motivational quote, says, H.G. Wells said, "If you fell down yesterday, stand up today." If you fell down yesterday, stand up today. Alan Batty says, I'll pull a motivational empowerment card. Can we reflect upon the evidence that was tampered with by the paranormal forces that be, but only those items that were in the custody of the state or witnesses for the state? Yes, let's reflect upon it all. Reflect upon all of it. Here's your empowerment card of the day. Do more of what makes you happy. Do more of what makes you happy. I'm going to see you tomorrow morning, my friends. Get a good night's sleep, because who knows what's going to happen.